No one seems to know how that gets, that data gets there.
We also
And
have a copy of this
it's,
because it's one
true
block
point
and
back,
doing it doesn't work.
so
Christian's
it's a
on
true
touch.
point resident justice, not unlimited. So
Oh, great.
stay that way.
Man, I hate that.
I'll go get it.
You know,
And now I would make some computer company.
I'm gonna talk to him.
Okay. And then they'll get stuff in the mail. Look how I feel. Are you exhausted?
Just can't, something's going on, like the last couple weeks, I just can't keep up.
Yeah.
It's one of those, like, the moment I walk away from my phone, the light's blinking, and then as soon as I hit send on an email, there's 3 more,
Yeah.
and I don't know what it is, it's just weird.
Info
Yeah,
automatically enters or generates a hearing date based on when the complaint was made.
yeah,
100% of the time, I have to change it when I go in. These people back there, without even double checking, based on what the computer said, flew in here from somewhere.
oh my god.
And their case isn't even scheduled for March. Yes. He's talking to.
It's very dramatic. They're aware of the drama upstairs. Yeah. Because they say, well, show me what,
I sent her exactly. Planning permits, this, building permits, this.
yeah. They're being called on their bluff now.
Hi, good morning.
Always tell me about these poor folks. The gift that keeps on giving.
so I told him, as soon as this is done, they need to explain what they need to do, and if we need to give them more time.
Where'd they come from?
Where'd they come?
I didn't ask him, I was talking to him, I just wanted to let him know, we'll give him one more time to, you know.
I don't even think it's scheduled for March yet. Don't
I'm
recall
not
seeing
sure,
that
I'm
in
not
March.
100% sure what that would be.
Is Miss Antrim going to be here?
Yes, she actually had to step to the vehicle, but we're going to get started.
Okay, all right. Is Citrus County ready?
We're ready.
Is that you? You
Yes,
are?
sir. we
Okay,
are.
all right. Good morning, everyone. I hereby bring this February Citrus County Code Compliance hearing to order. At these hearings, we follow an agenda, a copy of which is available to you. First item on the agenda is the call to order. We just handled that. The second item is the pledge to the flag, and I'd like to ask you to join me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Good morning.
Morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay. So the next item on the agenda is dealing with the minutes from the January hearing. I've looked over the minutes. They satisfy the weight test. Are there any proposed changes or modifications to them? Hearing and seeing none, I will go ahead and approve the minutes.
Staff update, abated and continued cases are listed out front.
All right, thank you. Good morning again, everyone. I'm going to read to you a brief statement. My name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That is a fancy title created by the law, but what it means is that Citrus County has hired me to preside over your hearing. What I'm going to tell you during this opening statement applies to each of your hearings, so I'd appreciate it if you would pay close attention. When your case is called, please come forward. You will be placed under oath. If you are appearing at a hearing like this for the first time, I will state the alleged violation and allow the county to present its case. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present evidence in your case if you wish. That will be your opportunity to present evidence and make legal argument. It is important that you take your time during this process because it's likely going to be your only chance to make your case. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you should not interrupt any other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must abate the violation by that date, that means fix the violation, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on your property. The county also has the right to foreclose on that lien or seek a money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or remedies to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate this into all of my orders as standard provisions. If you bring your property back into compliance during the time that I allow, the cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs. Are there any appeals of orders to demolish?
No.
No.
Yep, okay. All right, ladies and gentlemen, you do have the right to appeal any order that I make today. Thank you very much.
First two cases on today's agenda, Vanawa Holding Corp. Incorporated, case number 2023-00117, and case number 2023-00560. Code Officer Alan Jonason. Page 30 and 31 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Sir, please state your name.
Martin Vincent.
Thank you.
Good morning.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2023-0017, Citrus County Land Development Code, Section 3102, Special Requirements for All Accessory Structures. Case number 2023-00560, Citrus County Land Development Code, Section 3150, fences, hedges, and walls. The address of the violation is 6101 East Turkey Trail Drive, Hernando, Florida. Property owner is Vanawa Holdings Corp. Incorporated. I have good service via fine appeal email request from the property owner. This is a fine appeal for cases initially heard on 18 October 2023. On 18 October 2023, in a special master hearing, respondent was found guilty and granted 60 days to abate the violations. If the violations were not abated, a penalty of $100 per violation per day was ordered. A compliance inspection conducted on 26 December 2023 revealed that the violations had not abated. On January 3rd, 2024, a copy of the unrecorded orders imposing fine in the amount of $100 per day per violation, plus administrative costs of $376.42 and $45.50 beginning on 26 December 2023, was sent via first-class mail advising of the 20-day deadline to request a fine appeal. On 19 January 2024, the respondent requested an appeal via email for each case.
Has the property been brought into compliance?
It has not.
Okay. All right, so what is the basis for the appeal?
No, well, the property has been brought in compliance, and I've got evidence to prove otherwise, and we didn't get the letter, which I had an email, literally on the 19th of January, so, and I have emails here with corresponding with the code enforcement office, which his email has been tagged into. Saying, hey,
Well, as a first matter, I don't think, I think your appeal's timely. I'm not dismissing the appeal because it wasn't received timely. We're hearing it. Yeah.
I'm just responding to everything.
Oh, I see. Okay.
Yeah, we through the emails, I did notify them that we had, satisfied everything that needed to be completed, and I brought up further concerns of what appears the fencing side that it's not compliant within a couple inches based on the photos that he shared with me. Is because there's constant road grading out there, and it's creating channels. And from the time of the photos that we took, which was correct on the date on the 20th, 12th, 2023, and I can give those to you whenever. But we took a steel pole. We had it measured and 1 inch below 6 foot, and everything. We had several site locations that we did that, and it was within compliance. And when he sent the pictures, and we got those after his inspection on the 26th, because
You're saying that after I made my findings, that you did make an
Yeah,
attempt
we
to bring the,
immediately- yeah.
hold on a moment.
Yeah, sorry.
Let's just make sure we're on the same page. So, to go back, you're basically saying that after I issued the orders, finding that the property was not in compliance, y'all went out there and did try to bring it into compliance
Correct.
before I signed the order and imposing the fine.
Correct.
Okay. All right.
Yeah, and we had, and I talked to Mr. Allen because he had cited us for another, vacant or storage property out there, which I had a couple trailers out there, so I had dump trailers, storage trailers. I held all of our equipment and stuff that was holding all of our tools. I had a couple farm trucks out there. All that's been removed, and we had to. You could see in the pictures, that he took on the 26th that the dump trailer was there because we had, more fencing and stuff that had to be disposed of, and we still got piles of chopped up fence and stuff that we chopped up out there, but because after we got that notification, we're like, well, we're not going to bring out equipment and try to clean up if we're just going to continue to get fines, and we feel like we're being harassed at this point.
So you're
because
admitting,
we're trying to do
what that sounds like, so I hear you on the fence, and I'm gonna ask some more questions about that, but it sounds to me like you're saying there was still stuff on the property at the time that, regarding the storage case, and you're,
Well,
it's
no,
still
we
there?
we removed everything,
Oh.
but we removed everything to abate, so we could, satisfy everything. But after Christmas, we brought one dump trailer back out there because we still had, we cut 2 feet of fence off. And, we had like almost 1,000 feet of 2-foot fence sections and tons of poles. So we were trying to clean up all that, and I literally dropped that off the day after Christmas, the morning of.
Is it all gone now?
It's all gone now, yeah. When
Okay.
I got the email and said that, I was like,
So you don't have anything left on the property as of today?
no, there's nothing on the property.
Okay,
And I
well, let me just talk to Mr. Johnson. So, it's your understanding that in both of these cases, the property's in violation?
Yes, sir.
Okay, so what's going on? I mean, I would figure that on the storage case, that's pretty easy to demonstrate, right?
Well, I have photos for both cases, along with the exhibits from the initial cases that I can present as evidence.
I just
the
want to talk
fence-
about storage right now,
Yeah,
not
there's
fence.
a lot of items. There's water tanks, there's the structure that he had on there is still there. The clear tarp has been removed, or whatever the covering was, but there are still items stored on the property.
And do you have photos of that?
I do, yes, sir.
Okay. Do you hear what he's saying?
Yeah, so that was a greenhouse, because we have the hemp permit.
No.
to grow-
So
yeah.
here's my question. Is there still anything on the property that
No,
should be removed?
We've got the totes, but we moved them onto the other side of the other property that's, has the house on it. That's the whole issue, is we put in for unification, but the unification didn't go through, because we didn't pay the property taxes, because we were filing for the ag exemption. So,
Okay.
we got denied the ag exemption, so the unification didn't go through.
So
We
it sounds
did-
like you're trying,
Yeah, we've
but
been
then
trying for the
it's-
past year and a half.
but,
And it's been trying to get these things, and we paid the taxes, we've got unification set up, but now the Prager's office told us to get the unification completed, we have to wait for our bank
but
to
the
sign off.
unification has no relevance towards what we do here.
Well, but that's for the, allowing us to build the greenhouses out there. We've took all that stuff down, but we wanna be able to put our greenhouses and stuff back up.
All right,
So we have those in the garages, they're on site, but they're on the 6060 East Forest Trail address.
All right, then based on what you're saying, I don't think we have a choice but to go through your photos on both cases.
Yes, sir.
Yeah.
I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, a copy of the findings of fact and conclusions of law and order from the 18 October 2023 hearing for both cases, and a copy of the first order imposing fine for both cases. Exhibit B1, photos from Exhibit A from case 202300560 from the 18 October 2023 hearing. Photos from my compliance inspection on 26 December 2023, and photos from 20 February 2024 showing the violation has not been abated. Exhibit B2, photos from Exhibit A from case 202300117 from the 18 October 2023 hearing. Photos from my compliance inspection from 26 December 2023, and photos from 20 February 2024 showing the violation has not been abated.
What was the date on that?
20 February 2024 was my last inspection
All right.
yesterday,
Thank
sir.
you.
And Exhibit C, a copy of the email requesting the fine appeal from the property owner.
I'd like to ask you to show, have you seen these photos and exhibits?
I got a couple of them from the email.
Well, take a look through them and let me know if you have any objection to them being evidence here.
I was supposed to get this.
Whatever Mr. Jonason has handed to you, I'd like to ask you to look through and let me know if you have any objection to them being evidence here in this hearing.
And I was supposed to receive these orders, cause I never got any of this stuff.
Well, hold on, so we can talk about the documents, but I don't know exactly what you're looking at. Can you show to me what you're looking
It
at?
says the order imposing fine.
Yeah, you should have received a copy,
I didn't
or at
get
least
that.
it would have been mailed to the address for the property.
Okay.
Also,
This is when it
Lori,
was
I
all still
won't need the
8
break
foot.
at 11.
Oh,
Yeah,
okay,
I resolved
thank
it,
you.
yeah.
You know, these are the ones you sent me in an email.
Time, date, stamp there for you.
Okay, and so for,
These are for the storage case.
it's 9/11. All that's been,
Those are from the first case.
Are the county attorney's gonna wanna look at these documents? Okay. Mr. Jonathan, could you bring what he's already looked at over to Ken, just to speed up the process?
the same emails I have here.
Do you have any objections to these documents being evidence in this hearing?
For the ones that were taken on 12/26, because the ones that, the photos that I have on the 20th that we took, show that we are in compliance, whereas the ones that he shows it's, there's been some type of alteration within the soil or the sediment, like I was
Okay.
saying with the grading.
And so that relates to the fence case?
Correct.
And you have your own photos?
Correct.
Okay, all right.
Yeah, and with the storage, greenhouses have already been taken down, and, like I said, the totes, we have the totes, but they're on the 6060 East
Well, I'll just let you know
address.
what I'm thinking. I mean, if there's anything that's still on the property, then that's gonna be a violation
Well,
of the
there's two
storage.
adjacent properties,
I
6101
understand
and
that. What I'm
66.
saying is, if there's anything in the property at hand that,
No, that's all been moved over to the
okay,
property
so
that has
that
the
may
house
be
on
a
it.
different issue.
Yeah.
I'm just telling you my thoughts. So if there is still anything on the property, I'm gonna deny the appeal on that. But the fence, we'll have to get into. I wanna get your photos. I wanna understand what's going on. But let me
And
look
I
at
do have a
what's.
witness here, too, a
Okay.
professional witness.
And you, that's great. And is your witness for both cases or just the fence case?
For both.
Okay. just take a moment to look through all this. I'm going to admit it all as evidence. The objection I heard is fair, but I think that's more a statement about what the evidence shows, that there may be other evidence that bears on the relevance of the evidence. So let me just go through. I'm looking through the storage photos.
Well, essentially, with the photos that I have provided, it shows that we were within compliance, and, you know, that justifies and satisfies any, or abates the, you know, the concerns. And, you know,
Okay.
based off of his photos, if there was, you know, water runoff, which is in a highly flooded area out there.
Mr. Jonason, so my question about the storage photos, I want to make sure I understand what I'm looking at, what you're taking a photo of. So on the last few pages, I'm talking about pages 5 of 6 and 6 of 6 of Exhibit B2.
May I approach?
Yeah. What does this show?
So these appear to be water tanks of some sort, or some kind of tanks, and then this is the structure that is in these earlier pictures, this structure.
Mm-hmm.
But the tarp
I
that
see.
has been
Right,
removed
right.
from it.
There's an effort being made.
Still
But is this on the property?
It is on the
He's saying that it's,
It is not.
okay.
It is not on the property.
So I guess
The other.
what I'm trying to understand, I'm trying to understand why this isn't a violation still,
What do you
Mr. Van Sant. The white and the wooden structure that's still there. It was originally a violation in the case. It's still a violation. It's still there.
We removed it. So the only thing,
On February 20th, I have a photo on February 20th that it's still there.
the greenhouses have been removed, all the tools, everything has been removed.
So some things have been removed, but not everything's been
No,
removed.
everything was removed.
Every-
Everything that you can see from that is on the 6060 East Forest Trail address, which is the address that has the home on it, which we were told by the code enforcement office, that's fine. And we were told by the property appraiser's office, the reason we can't store on there is because the vacant property, 6101 East Turkey, that's adjacent.
So you're saying that what I'm looking at in the photos, the structure with the white tanks is not on 6101 East Turkey Trail?
Correct, it's on 6060. Because 6101 comes through at an angle, and it just barely touches the fence line of the interior fence of the grow area that we have. And then it goes at an angle and connects at the farthest corner
But
of the
I'm
property.
looking at the photo from September 11th, 2023. Are you saying that the area with the white tarp in this photo was also on the neighboring parcel and not on 6101?
Correct, which was the argument the entire time, that we were already in compliance. And the interior fence, which is a 4-foot fence, we acknowledge it's inside of the area, but that wasn't brought up or addressed. That was just something that we had already there as part of the cultivation for our hemp permit.
Well, here was your argument at the prior hearing, that it was developed as a hemp farm, that you've received all state and federal DEA and EPA approvals, that there's an application for ag classification which was denied, but that you're appearing in front of the VAB board. I don't see anything about what you just said, and I'm just making sure.
Yeah, and those statements were made by Mr. Leon, whatever. his
Your
name is,
attorney.
The attorney who I fired. You know, the
Well-
statements that I made weren't recorded into there. You guys only recorded what the attorney said.
Well,
And I fired him because he's an idiot. He has
it's
no
all on
idea about-
video. It's all on video.
Yeah.
But the thing is that you just said that your whole case and your whole argument was this, and I'm reading, that's not what your whole argument was. It doesn't
That's
mean
what I
it doesn't
said.
mean it's not valid. I just want to get the record straight. And I'm looking, and there's, let's see. Is there anyone from the public who and I understand you have witnesses, we'll get to them. Is there anyone from the public who wants to be heard on this? Because there was last time, so.
Yeah, because it was a witch hunt, because there's a make-believe HOA out there. It's not a legal HOA. Jessica, who's noted on there, came out And she wasn't happy that we were out there, and she said, well, if you're building a hemp farm out here, we're gonna make sure that we've got friends in code enforcement, we're gonna come after you. You guys, they were weaponized out there, and we were never offered due process. We were denied proper due process in the entire stage. We were just, next thing we knew was we had signs posted out in our front yard, and we were told that we had to go to code enforcement. We were never talked to or addressed or anything like that.
Well, this
And
hearing is due process.
prior to that point,
Yeah,
though,
yeah, yeah.
the proper due process would be, we are notified of a potential violation, because they made, and on record, she said, from the day that we purchased the property, that they had issues with us being out there. And we were never offered the due process from code enforcement. Yes, he said he got his, it wasn't an anonymous, tip. He had somebody call in, but he never talked to me personally. He said he talked to us on the last record. He never talked to me.
Why is the white tarp not there anymore?
We removed it all. We removed the structure. Everything out there has been removed. Like, it's all been moved over.
I'm looking at pictures from yesterday that show there's still a structure there. That's what I just don't understand.
That would be the interior wood fence. There is a wood fence inside.
Right.
Because for the hemp permit, we have to have an interior fence for the actual cultivation site.
But that's what we're talking about here.
That's
in
not what he was
violation.
talking about. He was talking
Is
about
it
the
a part of the
buildings.
violation?
Yes, sir.
Okay.
That's not what he said.
And
He
what
said
if
the
you-
buildings and the greenhouses. When I talked to him on the phone,
No, sir,
he said the
sir.
greenhouses.
This is about a
does.
vacant parcel. It's gotta be vacant. There's nothing that's allowed to be on there. That's why I keep looking at these photos and I don't understand
And
your
again,
argument.
when I asked him, what specifically are you talking about?
Okay,
Because-
everything.
yeah.
Is that right?
Yes, sir.
Okay,
No, he
so
didn't say
that's,
everything. He said, well, the totes.
all
He said the
right. The appeal on the
greenhouses.
I never
storage
said
parcel's
that, sir.
He
denied.
said,
Let's-
oh, there's-
Let's
I
go
never
about
said
the
that.
fence. Who are your witnesses?
Nathan Brazo.
All right. I want you to have actually, I'll undo the denial on that because you said the witness did have argument to make on that. So I do want to hear the evidence.
And did you want the photos? that we did?
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Please state your name.
Nathan Brazo.
Thank you.
Is that up to you?
Yeah, and whatever, so this is your opportunity. I mean, ask whatever questions you think are appropriate, and I will as well. Actually, could you show these first to the county attorney?
Mr. Brazo, how do you spell your last name?
Brazeau.
Thank you. I'm good.
Does the county have any objection to these documents?
The only thing is, I think the emails might be duplicative, they might already.
Okay,
be in
that's
the
okay.
picture, right?
That's fair. All right. Then, without objection, I'll admit these as, let's just say respondents A. And actually, let me take a look at these before y'all continue. tall are you, Mr. Frezzo?
I am 5'9".
Okay, that seems relevant based on the photos that I'm looking at.
I would like to make a remark as well that the grade of the actual ground pitches and troughs anywhere between 8 inches to 10 inches in any given point.
Okay. All right, so I have now looked at the photos as well as the emails, and we do have some duplicative emails. That's not a problem. All right, please proceed.
All right, so I've been working on this fence now for over 6 months, and I've remediated it twice now. Took over 48 hours. We brought it down from 8 feet down to 6 feet. And then when the code enforcement came out, he took pictures. We remediated that issue as soon as possible. The roads are being illegally graded by a man down the road. As you heard from Martin here, a certain man has been grading them and basically creating pitches and troughs. So every time the runoff comes, now our fence gets taller, which I find it to be unfair. Anybody can come out at any given point and find one of our poles is now 1 inch taller. And so now we're going to lose our family's property, and that doesn't seem fair to me. We've been working very hard at this project, and I would just like to see some type of compassion, for farmers in Florida. So, thank
You
you.
can see in
Does-
the pictures too that, where the soil has completely eroded down, where you can see the concrete that was poured all the way down, and there was another 8 inches of soil. It's
I can see what
completely
you're
eroded.
talking about. Does the county wish to cross-examine? No? Okay. All right, I appreciate your testimony. Well, I heard you also had testimony about the storage part of,
Yeah. We basically took down the entire structure. There's no longer a roof out there. There is the wooden poles out there. Obviously, he's already made the case that we're trying to get the unification, but everything has been moved. And so at this point, we're willing to do anything that we have to come into compliance. That's it.
all right. I'm going to deny the storage case appeal because it's clear that there's still things on there. It's not just the roof, it's the structure, it's everything on the property until the principal use is established, unless I'm wrong. Am
No,
I
you're not.
wrong? Okay. That one's easy, but I do want to talk about the
Is
fence.
principal use established through the permitting? Because both addresses are.
You don't have it, and so it was a violation then, it's a violation now. You've said that it was all gone, that's not true. The photos show it's not true, your testimony shows it's not true. That case is easy. The fence is not, and so I want to talk to you about the fence. How is this fence still in violation?
So they did remove a bunch of the fencing that was up at the top. However, the fence does this. It wasn't cut, it wasn't like somebody did a chalk line and did it exactly straight. It wavers, and there's some areas that are 6'2", some are 6'4". The board that's used in the measurements is 6 foot a quarter inch tall. And with the benefit of the doubt, I put it in different areas along the fence, and you can see that it's,
You're saying the piece of wood that is in these photos?
that I use to measure, yes, sir. It's 6 foot and about a quarter inches long. You can see that in the photos. It's right about 72 and a quarter inches.
So obviously originally there was a couple foot gap.
It was an 8 foot fence.
Right, and then, but later on, I'm just trying to, okay, so now I've got your current, or the December photos.
Yes, sir. And there's photos from yesterday as well. And it doesn't appear that there's much change, if any, from the December photos to the
I mean,
yesterday
I'm looking at
photos.
one February photo, and it looks like it's below the wooden,
In some places it is, yes, sir. Some
Okay.
places it was cut less than 6 feet.
remediated every last pole, but as you know, when the graders come and keep pushing off all the lime rock on the side of the road, it creates those ravines which make this fence taller or shorter in some given points, and doesn't make sense.
If you look at the photos, you can see the grading they're speaking of. It's in the roadway, which is about 1.5 feet, 2 feet away from the fence line.
Well, I do see both sides on this. I agree with you about the grading, but I also see, I guess I don't, it appears that the fence was cut down to different heights, and I don't understand
was.
why.
It was, some areas it's,
Well, you can tell that it's cut to different heights, so I don't understand, why wouldn't you cut it all down to one height instead of, it's zigzagged?
Because the grade of the ground is a differential of 8 to 10 inches in some given points, because the ground is never at the same level, because it's being illegally graded by a man down the road
Okay.
that actually doesn't have jurisdiction to do that. We have rains like once a week, and when the rain comes, it washes out our line.
Specifically in December, from 20th to the 26th, we had rain, and there was a lot of water, and the roads themselves were flooded. There were several areas of flooding, and it washed out a lot of the sediment that was in that area. And all they do is, once it washes out, they just come back and they push it back up against the fence.
To be very fair, I did do a chalk line, and I've never done a fence before, but I myself erected a $20,000 fence with a couple other people, and I think I did a pretty good job at it. I'm just a farmer. I'm just trying to save the world here. So.
And to be quite frank, honestly, we should have had this unification paperwork already done, but it's just, we're constantly getting tagged on with, other things and stipulations that we have to meet, instead of just giving us everything all at once so we can just attack it. It's like, oh, well, you did all that, now do this, and now do this. And it's been a year and a half, and we're finally getting to be able to cross that line now, and it's been extremely aggravating, because we have other farms, and we've been built out, and we've been done very successful in what we're doing. And, we haven't had much direction and support from at least from Citrus County, as regarding what we need to do for, getting the infrastructure that we need to get built out, or how we get the proper deed and titling, because before we even made acquisition of the property, as I said last time, we talked to the code enforcement, we talked to the building and zoning department, we talked to everybody that we needed to talk to before we came out with money to buy this land and secure it for the family growth. And,
When y'all cut the fence on, or around December 20th, did y'all talk to code enforcement and ask them?
prior to, so we actually.
I'm sorry, I'm not, I know it sounded like I was done, I wasn't. Did you call Mr. Jonason and ask if he would come out and check on after y'all did what you needed to do?
Yeah, I talked to him on the phone, because we had another thing that he cited us for, like I said, we had a couple farm
It was a
trucks.
simple question, so I think the answer was yes. So, Mr. Jonason, when you came out, when did you come out after December 20th? Like, after they
so during
dramatically lowered the
the
fence?
compliance inspection that you ordered me to do, I conducted that compliance inspection, and then I didn't inspect again until yesterday, because there was no request to do anything.
Right, but I guess where I'm going is, did you make it clear at your compliance inspection?
There was no one at the property.
I got you, okay. So the first time when was the first time you became aware that the fence was not in compliance after you cut it down?
On the 19th.
When I issued the order?
Yeah, on the
Okay.
19th, when we got the issue of fine, and then I just emailed immediately, because I thought, when I had emailed previously, like, hey, we did everything, and I talked to him on the phone, said, hey, Christmas coming up, they're trying to get everything
Well,
done
listen, here's what I'm gonna
before the
do.
20th.
I am gonna find that it's still in violation, but what I'm going to do, because it's unarguable to me, but at the same time, it's also clear to me that you dramatically decreased the size of the fence. It went from 8 feet to between 5'10" and 6'2"-ish, 6'3"-ish. The average height may very well be 6 feet, but there are portions where it's higher. It doesn't look precisely cut, to be honest, and I have to follow the code. What I wonder about is, in terms of the fine, whether or not it's brought into compliance is a factor for a fine appeal. But is there any, and I'm not faulting anything, to be clear. I don't think you did anything wrong, Mr. Jonas, and I'm just for my own good faith, I'd like to ask the county attorneys what kind of discretion I have on a fine appeal where I find that there was a good faith attempt. There may even have been a misunderstanding about whether it was in compliance. In other words, at the time they cut the fence down, I think they had every reason to think it was in compliance, to be honest. But it wasn't in every part. What discretion do I have?
Do you have a copy of the administrative code provision?
Hopefully I do.
I can bring it, I can give you one if you don't, I've got plenty.
What is the number?
AR 10.12-2.
I do have it.
And the date's August 28th, 2012.
Yep.
On number 5, it says the request for release shall not be accepted if among other reasons. And if you look at D, it says property owner did not use her best reasonable efforts under the circumstances to abate the violation. That would be what you would be considering today.
You're right. Thank you.
May I ask, what is the actual grade? Where do you guys
I'm
take
not
the grade
here
off?
for that, but here's the thing. Let's assume then that I see that section and I think they did use good reasonable efforts on the fence. I sustain the appeal, but I still see that it's in violation. I still want to compel full compliance. In other words, the portions that are above 6 feet need to be reduced to 6 feet. Is there any option I have to sustain the appeal, but to compel compliance?
Do you want to continue this to the next hearing?
Yes, I do.
And
Is there a possibility that we'll have a solution before the next hearing?
I think that would be the respondents. I'm looking,
I see, okay.
but I'm
Do
also
you
looking
understand
toward-
what I'm saying here? I'm saying that I find that you did try to comply.
Look on the photos that we supplied on the 20th.
Listen to what I'm saying before, if you would, listen to what I'm saying before responding. I'm finding in your favor that you did something good, that you acted in good faith, that there are portions of the fence that are indeed in compliance, as you have told me. However, I am also finding that there are portions that are not. Whether it's your fault or not, I'm not exactly sure, but it does look like the fence was cut in different areas. I'm not convinced that it's just the grade. I want to give you an opportunity to bring it into full compliance, because I will very possibly sustain your fine appeal on the other case as well, if that is done. It's a simple fix. It makes everybody happy, and you have the ability to do it. You've done it before. So I'm going to continue this to the next hearing. You've already prevailed on one appeal, okay? Does that make sense?
Yes, it does. Where are you measuring from? Where,
I'm sorry, you've failed on one appeal. I'm sorry. But I think you will prevail on this one. I'm sorry, what was your question?
I'm just curious, where does according to Citrus County stipulations of how roads are done and where the grade is at, they say the grade is where the road is at. So if you look at the road, it's flat, and then on the gullies it goes down. So if you're measuring from the road, then everything's actually within compliance. But if you stick a stick in the ground there, obviously the gullies. So how can we remediate that? Where do we
Well, that's where
measure
height is
from?
measured from. So, I mean, I think
It's measured
that
from the road, sir?
it's measured from where the stick is.
Okay. So how?
Probably with each individual stick.
So in the future, do we have to cut our fence every time it rains? Is that what's happening here? I just don't
I'm
understand.
trying
how
to work
do-
with you guys.
Understood.
Do you understand what I'm trying to do?
Yeah, you're
All right.
helping us. Thank
So
you.
I'm going to
Okay.
continue that hearing to the next one, March 20th? All
And
right,
that's just for the fence, correct?
just for the
So
fence.
the other appeal is denied?
It's denied,
Okay,
yes. All right, thank you.
thank you.
Next case on today's agenda, Jaime Ravenez and John Pajeski, case number 2023-00357, Code Officer Amy Becker, Land Development Director Joanna Coutu, expert on the case. Page 22 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
You do.
Good morning.
Good morning.
Amy Becker, Citrus County Code Compliance Officer. This is case number 23-00357, a violation of the Citrus County Land Development Code, Section 3102A. It's a fine appeal. The address is 229 South Barber Street, Beverly Hills, Florida. The property owner is Wamy Reverens Pojesic and John Pojesic. And I have good service via the fine appeal was an email request from the property owner. The fine appeal for the case initially heard on September 20th of 2023. On September 20th, 2023, in special master hearing, respondent was found guilty and granted 90 days to abate the violation. If the violation was not abated, a penalty of $25 per day was ordered. December 26, 2023, compliance inspection failed. There's items that remain on the property. A copy of the unrecorded order imposing fine in the amount of $25 per day beginning on 12/26/2023, plus administrative costs of $322.86, sent via first class, advising of a 20-day deadline to request fine appeal.
Are they here? Is there anyone from the public who wants to be heard on this? Appeal denied.
Next three cases on the agenda. Jesse Dustin Aaron, case number 2023-00713, case number 218-2353, and case number 2023-00730, pages 5, 6, and 7 of your agenda. Expert on the case, Joanna Katu, Code Officer, Brandon Norman.
Don't they have an attorney on this case?
Yes, Mr.
Yes,
Grant,
sir.
I believe he emailed you.
Yeah,
Yes.
saying that he'd be, I don't think we should take this up until he's available. Thank you.
Next case on today's agenda, Tammy Hebert, case number 2023-01036, Code Officer Brandon Norman, page 17 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name.
Tammy Heber.
Thank you.
Good morning.
Good morning.
Good morning. Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-01036, Special Requirements for All Accessory Structures, a violation of Citrus County Land Development Code, Section 3102A. Address is 6100 Old Floral City Road, Floral City, Florida, 36636. Property owner listed as Tammy Heber. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on October 19th, 2023, my corrective action inspection done on December 18th, 2023, and my final inspection done February 19th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
So ma'am, since this is the first, I think, from the get-go case we have today, normally what I do is I ask you to look at the documents that they have and take your time. Let me know if you have any objection to them being evidence in this hearing. Before I hear from you, I need to know what they're even alleging, and I don't. So that's why it's important to let them present first.
Yeah, these are open.
Okay, thank you. All right, thank you. Without objection, what's been proposed as Exhibits A and B are evidence. Please proceed.
On October 19th, 2023, an initial inspection was conducted at the property for storage on a vacant parcel. The property was found to be in violation due to a storage shelter being on the property. The property remained in violation of my notice of violation corrective action inspection on December 18th, 2023, as well as my pre-hearing inspection conducted February 19th, 2024. I have had contact with the property owner in the past, and the last we had spoke, she informed me that she was not going to remove the storage shelter from the property.
Okay. Is there anyone else from the county who wants to testify?
At this time, I would like to introduce my expert, Joanna Coutu.
Good morning.
Good morning. This is about a third of an acre in a residential lot, CLR MH. My records do say in the 80s there was a mobile home here. It's since been removed. So our records have it vacant.
And so in order for storage or other things to be on this property, they need to either establish a principal residential use, or could that be done with a mobile home?
Yes,
in this?
either a site build or a mobile home in this case, yes.
And they need a permit for that?
Absolutely.
Okay, and no permit's been requested or
Correct.
issued?
As
All
of,
right.
as of yesterday.
All right, so Ms. Heber, I'd like to hear from you.
So my understanding was that the initial complaint was not about the storage unit, but rather about the RV that was parked there. That was taken care of within a week with my being notified of it. Prior to that, there was a mobile home there. October of '22, it burned. I since bought the pile of ashes. I purchased the property with a pile of ashes. I cleaned that. At the time that code violation was cleaned up, it was cleared with that detached garage that you see in the picture there, still on the property. And I was told at that time I was now within compliance. So now this current.
What, did the county have this exact same case? Was it the same code section that they brought the case on?
What do you mean?
You're saying that there was a prior code case?
There was a prior code
Yeah.
violation because the burned structure was still there.
Okay.
I cleaned up the structure, the detached garage remained.
All right, so to be clear, it may have been cleared as to the burned structure, but that doesn't mean because one case is closed that there isn't another violation on the property.
Correct, and I'm not disputing that.
Okay, all right.
But at that time, which would have been around April of '23, April of '23, I was under the impression that case was closed, everything was taken care of, the property was within code standards at that time, when the detached garage was still there present. Since then, there was a camper that was parked on the property, and my understanding is that was what the violation was against. The camper issue was resolved. The detached garage, which has been there for 14-plus years, was still there. And now I'm being told that can't be there. So I'm kind of confused as to why in April was it okay, but now it's not. I get that that's how it's written in the codes. I'm not disputing that. My intent for the property, I'm sure several of you understand or are aware of the history of the property, literally looked like a junkyard. There's still, even after the rains, a lot of debris that comes up. I'm not in a position ready to build with still debris coming up. I want the land to settle and be cleared and clean. My intent is to build a solid structure, a concrete structure. I don't want to put another mobile home back in there. I'm on your side. I want the community to look better. I don't want just another trailer sitting there when I have the ability to build a nicer home. But to do that now is not the best time to do it. The garage that's there, it's in good shape. I've kept the land clean. I've kept the
It does look
grass
good.
cut.
I mean, it looks
I've
like a
done-
good piece of property.
I've done repairs to keep, I don't want it to be an eyesore to the public either.
Well, look, you have two ways of fixing this. One is to remove it or to establish some kind of a principal use. And I've heard what you've said.
Right.
But what it turns on is how much time I need to give you to do one of those things.
Mm-hmm.
So I really am tasked with providing a reasonable amount of time to get something done. So I'm not going to just say 14 days on something like this.
Right.
But I would like to have some feedback from you about the amount of time you might need to bring the property into compliance with either of those two things.
Right, and I believe you and I had spoke about this before too. The possibility of converting this into a primary structure rather than building another structure now.
Like a tiny home or something?
Yeah,
I don't know if that's even possible, but that would impact, how much time y'all need. I don't know anything about that. I just know the amount of time that I would need to give to bring it into compliance, and I want to be reasonable. Do you have any idea how much time you might need? Because you could work together on trying to convert it, and if that doesn't
Yeah.
work out, then you need time to get it off.
Yeah, I mean, I briefly spoke with the permitting department last month when I was here. I live in St. Pete, so I'm not here all the time. Briefly discussed it with them. They said, yeah, I should be able to do this. I need to get engineering and this and that on
Right.
the structure and everything. So if we can go that route, that shouldn't take very long, 4 or 6 months.
Does the county have any immediate health, safety, sanitary concerns regarding this case?
Not at this time.
All right, what's the county's recommendation?
The Citrus County Code Compliance,
Anybody from the public?
oh,
I'll get there. What's the county's recommendation?
the Citrus County Code Compliance Division would like to request that the special master assess a fine of $100 per day along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, and this amount is appropriate given the severity of the violation as well as the respondent's actions relative to this violation. We would also ask that the special master find it's the respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
Is there anyone here from the public who wants to be heard? All right, I don't see any. What I'll do is I will grant 5 months to bring the property into compliance, and if it's not brought into compliance as ordered within that time, a fine of $100 per day will be assessed. All right?
Thank you.
Good luck.
Next case on today's agenda, Ernest J. and Linda M. Sparks, case number 2023-01127, Code Officer Brandon Norman, page 28 of your agenda.
What page? I'm sorry.
28.
28.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please state your names for the record.
Ernest Sparks.
Linda Sparks.
Thank you.
Good morning.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-01127, a conflict with Central Water Facilities, violation of Chapter 42, Article 2, Section 42-39B of the Citrus County Code of Ordinances. This is for address 8321 South Great Oaks Drive, Floral City, Florida 34436. Property owner listed as Ernest J. and Linda M. Sparks. I have good service via posting at the property as well as the Lecanto Government Building, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be a notice of 365-day compulsory utility connection case packet provided by the Floral City Water Association, documenting attempts to notify the property owner by certified mail or posting at the property. Exhibit B will be a copy of my notice of violation, a copy of my notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, as well as a photo of the posted notice of hearing of the property.
All right, ma'am and sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
I don't understand this letter sent in 2022.
No.
We didn't receive any letter in 2022.
Okay, I'll allow you to comment on it and provide your argument.
Okay.
But what I guess I'm looking for is, well, I guess that is valid. So you're saying that one of the documents in your hands you've never received?
Right.
Nothing from 2022, no.
Okay. All right.
Hang on.
Okay, so all I remember receiving was the certified letter. That's all we received.
Okay, got it.
Why, I want to know why that we're standing here. And in 2005, this was brought up about landlocked. Our property is landlocked. And Floral City Water.
Sir, I do want to hear what you have to say, but I need them to be able to listen to it as well. And I don't even know exactly what they're claiming yet. So before I hear your defense, I need to better understand what they're saying you did wrong, if that makes sense. Because I can't answer your questions unless I know what they're
Right.
saying. I think I probably have an idea, but I just want to hear it first. All right, so what I'm going to do is I'm going to, let me just look through this for a second. Okay, I'm not going to admit them yet. I'm going to let you tell me about these documents, and we'll go from there.
Great. On December 26, 2023, I received a complaint that the property had failed to connect to the central water system after the 365-day notice period. The property was found to be in violation of the above ordinance. The property remained in violation of my notice of violation corrective action inspection done on January 26, 2024, as well as my pre-hearing inspection conducted yesterday, February 20th, 2024. I have had contact with the property owner, and they are aware of how to come into compliance. They have mentioned in regards to what they just spoke of, there's been no proof, and we've looked through all of our records that we can possibly go through to look for this letter that they're referencing, and it can't be located right now. So
The letter,
referencing from
I heard them reference a 2022 letter.
So there's a
You're talking about something from 2005? All right.
There's a letter from
We're not there
2005.
yet.
Okay,
Let
understood.
me
I have an
ask-
expert that can explain the
Okay,
documents.
thank you.
What date is the letter that you did not receive?
Ma'am, have you been sworn in?
Yes.
Yep, okay. And can-
My name's Caleb Woodard,
Thank you.
representing Floral City Water.
Great, appreciate it.
The original 365-day notice was sent on June 22nd. You should have a copy where the letter was sent back unclaimed. All following letters, a 90, 180, 30-day notice, were all staked at the home because we received the original letter back unclaimed.
Okay. And no one, okay, all right, I understand. And it's 8321 South Great Oaks Drive we're talking about.
Correct.
Okay. Let me look at are these copies of, are these records that you have in your possession at the Floral City Water Association?
Yes, I have the originals with me.
Okay, I just want to make sure. So there's a notice of requirement to connect from June 20th, 2022. You've provided me a copy of that.
Yes.
In fact, you're the notary on it.
Yes.
Okay. And you notarized it in June of 2022 for Tim Wilson?
Yes.
Okay.
Tim Wilson is our general manager, CEO, my boss.
And you also have a copy of an envelope that purports to be the certified mail that was sent to the Sparkses, correct?
Yes, sir.
And it's noted with a UNC in writing, which I presume means unclaimed.
Yes, from the post office.
Okay. I also have a copy from September 26, 2022 of 270-day notice, and from January 4th, 2023 of a 180-day notice. And you're saying that these latter two letters were staked on the property, and you've also provided, have you provided photos of that?
Yes, staked at the property. There is a gate that has both of their homes, their drive blocked. So we had it staked outside of the gate because obviously we can't go onto their personal property.
I guess one thing I don't understand is,
So from my understanding, Great Oaks Drive,
well, hold on. So on this 180-day notice, it's dated January 4th, 2023. The photo with the staking is dated January 6th, 2022.
yeah, so I was not able to go out and personally take photos. I had to have a water technician, and they did not.
It was a time-traveling camera?
Yeah, so they didn't timestamp it the day we put the letter up, so we went back out when I noticed that the pictures were not timestamped.
I see.
Originally.
Hence the second photo.
Yeah.
And you're representing that the second photo was taken in 2023?
Yes,
Okay.
so there is some timestamps that are wrong, like the January
Right.
of this year. our
And
text
so it
are-
happened again on March 28th. But it does correlate with the day and month of the letter. Okay. And Then there's a final 30-day notice.
which was, the final 30-day was certified mailed and staked.
We only received a certified mail from Court Enforcement.
And ma'am, if you could, if you lower the microphone so
Sorry.
that,
He's taller than me, it's not my
well,
fault.
you both should have the right to use it.
No,
So your testimony is that you didn't receive any of the letters from the Water Association?
No,
Nor did you
nothing.
nor did you see the notices that were staked?
no, and
One
this
that was staked
was 2 properties away,
on the Floral City,
the Tower Road.
the tower. That was on their property, not on ours, they staked it
Okay.
several times.
And so we said, that can't refer to us, it's 2 properties away from us.
On one of the photos, that is their mailbox right next to it. And the gate seen in the back, I believe, is the one that goes, they have 2 adjacent properties. So they,
I see what they're saying, so that's the relevance of their parcel being landlocked.
they own both parcels.
You own both parcels.
The first
I
parcel.
own 1 parcel,
She owns, and she's paying taxes on that one.
he does not own that.
You own the one that's in front of your landlocked
Yes.
parcel? Okay.
And only recently because I bought it from my mother's estate.
I mean, I guess that concerns me because there's photographic evidence that the letters were staked there, so how would you not know that it was for you?
We never read them.
You didn't read them,
Not on our
okay.
property.
They weren't on our property, they were 2 properties away.
Well, here's a photo that purports to have a staked notice right next to the mailbox in front of
And
the
that-
landlocked
And that's
parcel.
recent, they just done that.
Okay, when was that?
The last stake letter would have been in May of '23.
May of '23. No,
They just staked that one.
Floral City Water has not staked since May of '23.
No,
Okay.
yes, they did.
that's not true.
Okay.
Heck, the guy, almost dark time came out and found it, my daughter living in that.
She watched it.
And she watched them stake it.
Nothing in 2023.
All right, so let's look at the code section. Do you all object to having to connect to the water system?
Yes.
We do, yes,
In
especially,
2005,
the county commissioner wrote a letter stating that we were landlocked and we were not required. I looked up the code from that time and we were not required.
And do you have a copy of that letter?
I don't have a copy of that letter. They were sent
Jim
one.
Fowler was the commissioner at that time.
Okay. And what did that letter say?
It said, because we were, and he quoted the code, that since we were landlocked, we were not required to access that. I have since looked up 2 other things which said that if you are not accessed to their water line within 300 feet, you're not required. We are obviously thousands of feet away from their land, their line.
Our property is almost 1,000 feet.
All right, let me just look at the code section here, 42-39B. This code section does not have a distance threshold. In other words, it doesn't say if you're beyond 1,000 feet that you don't have to connect. What it says is that when the system has established that such system is available, they can let you know, and then you have to connect. And then it does provide you an ability to seek a waiver. In other words, you can seek a waiver based on financial or public health considerations. In other words, maybe you think your own water is better, or it's just prohibitively expensive.
We know it's much better.
Well, but either way, it's up to you to seek that waiver.
Floral City water does not even fit to drink.
Okay.
My daughter has
And I,
We do allow hearsay in these hearings, and so the cat's opinion is evidence.
can we swear the cat in? Come on, let's swear the cat in. I guess,
But here's your challenge.
Okay.
Your challenge is that I mean, no matter what a commissioner said 20 years ago, the law says what it says. We have to follow what these words say. Well, now hold on a sec. Well, people, because it's a democracy, people change laws. But what I think is you can bring this property into compliance one of two ways. Either you do the connection, or you seek a waiver based on the code section. If you go out and get a waiver, then I don't know if they'll be willing to do that after this, but that's one way that you can get rid of this.
Well, Floral City Water do not want to put the piping in and take it 1,000 feet back.
they're saying, we don't even know if they have not contacted us in any way, which I think is very ignorant.
I disagree. I think that you've seen, even if it's a recent posting or not, they've contacted you.
No, they have not contacted us. And the other issue is that there's been silence. I wrote letters to the county commissioner. I've even spoken to Rebecca Bays. And I've also sent to the code compliance, no response. It's like a big vacuum. Okay, we're trying to say, look, this is our stance on this, nothing back.
They
And
hear
here
you
we-
today. They hear you today, I can assure you.
Say yes, we would, if they want to go and dig that trench. I looked it up, Lowe's at 2-inch pipe, which you'd have to have 2-inch pipe to get pressure that far back.
It's thousands of feet.
It's 1,000 feet, plus it's $1,770 some just for the piping, not for the trenching, not for laying the pipe, not for the fittings, none of that. That's a lot of money, and they don't want to do it.
Yeah.
Plus-
My mother-in-law, Paula, they comply at 75 feet. They would not even lay the pipe for 75 feet.
Well, look, it sounds to me,
They told,
it sounds to me like you have a compelling waiver argument, but I find that this code section applies. And this mail was unclaimed. It wasn't not delivered, it was unclaimed. So I think that this code section does apply. What I need to know is how much time you need to either connect or seek a waiver.
we'll have to seek a waiver.
We'll have to
because
seek a waiver
we
because
cannot connect- we cannot even
he's
afford.
77 years old. He can't dig a trench.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they revised the violation and is appropriate given the severity of the violation as well as the respondent's actions relative to this violation. We would also ask that the special master find its responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
How long does it take to go through the waiver process with the Water Association, whether it's approved or denied?
The only waiver that I'm aware of, and my expert can correct me if I'm wrong, is a medical waiver from a doctor stating that the requirement to have the well water and not connect to a central water is the only waiver that I'm aware of. So, but I can.
Well, that would be
respond on that
illegal
one, though.
because the code section says there's financial reasons why you could, so,
Financial plus,
yeah.
both
So-
of us were diabetic. We got, she got stage 3.
Well, hold on. So if the association is saying today that it will not, under any circumstances, consider a request for financial considerations despite the fact that section 42-39 subsection B says that it would consider such a thing, I guess I'd be surprised. Is there no ability to take financial considerations into, but we're keeping in mind, I have no idea if it'd be approved or denied, but it's not possible?
We've never had an issue. We do offer a payment plan, but it's never been requested that they not obtain a membership due to financial reasons. I could, if they submit something, I would be willing to put it in front of our board of directors for approval, but I couldn't make that decision if there would be one today.
No, I understand that.
Yeah.
How long do you think a review process would take?
So our board of directors, who would make the final decision, meets once a month, so possibly
Okay.
I could bring it in front of the March meeting if they would
Okay.
like to present it before possibly March 15th.
All right, that's fair.
So the 200 and 300 feet means nothing even though it's listed out
According to
there?
I don't see it in the code. It's not in the code here.
It's even listed on their website.
Well, that may be true. It's not in the code section. You're here on a code violation because it says you've got to connect. All right, what I'm going to do is is there anyone from the public who wants to be heard on this?
Yes.
Okay, yeah.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Please state your name. Can you say it into the microphone, please?
Desiree Cooper.
Thank you.
Ms. Cooper, what would you like me to, what's your input?
Well, I think we can all agree that we all have our own preference of water, whether it be purified, spring, whatever.
Propel.
Exactly. Thank you. I don't think that it's fair that, one, they have to do such a thing. People have had wells for as long as we can all remember. And it's not fair that they're being forced to spend money on something they won't drink.
No, we won't, never.
They will not drink it. They are in their older ages. My grandpa cannot build no trench. They are both on Social Security. That ain't covering any kind of pipelining or anything. And for this to be even here today is disgusting. I don't think that it's right. My grandpa served. He should not have to worry about this. Neither one of them. They both have worked very hard their whole lives just to come down to something like this. It's disgusting. And I would really appreciate it if someone would please just drop all of this. Let them keep their well water. This is not fair, and it's not right. That's like going to a store and the owner of that store saying, you looked at that table, now you gotta buy it. The only difference is they didn't even look at the water. They don't want the water. So I would appreciate it if this could just all be dropped, because this is not fair. You're trying to milk a dead cow. They don't have the money for this, or the energy. That's all I have
All
to
right,
say.
thank you.
Can I get this picture?
Can you show it to the county first, and then I'll make a decision on evidence?
From the road, to back, you can't even see the house, it's that far back.
Okay.
It's like thousands of feet that you would have to do piping. And I have one other comment. When we dealt with Floral City Water before, it's almost like they've got a vendetta against us,
When did you deal with them before?
because we're paying the bill up the hill. When my-
When did you deal with them before?
It was,
2005?
it was 2019 when my son died.
Okay.
2 of our children have died here. And I was under stress, and they got a leak. And they called us frantically saying, oh, $750, you owe $750. I said, how could we owe $750? And they said, well, there must be a leak. So we said, okay, we'll get out here and figure out what's going on. They changed out the meter, but he discovered a leak in the road. And-
From the roadside meter, from them metering it into our house. No.
He discovered it for them. They didn't even discover it. They fixed it. No
But they-
leak.
And they never said, hey, we tell you should probably boil your water. They did not.
Nothing, no protections. And then they said, well, in order to make a deal with us and keep your water on, you have to pay $450 of this, even though we did not cause that leak. So there's a little bit of history there. And then, okay, this sounds really ridiculous, but I write to people all over the world, Australia, everywhere on this earth, and I sent out 5 checks on the 28th. All those checks went to wherever they needed to be, except Floral City. I called them up and I said, you haven't cashed my check to pay for the water bill. It's $26. She said, there's a $5 fee. And she says, you have to go in front of the board and try to get that $5 fee taken away. And I said, in front of a board?
Wait,
for
how do you
$5?
have a fee if you're not connected?
May I speak?
Yeah.
Up the hill.
So they have the home in question and then another home in front of it that's metered.
I see.
Prior to 2019, there was a leak at the original home.
Yep.
I actually have notes not with me because it's a separate account, It was a leak on their side, so the water was metered. That was the cause of the bill. The late fee that's been associated with the current account, we never received payment for it. It has not, as far as my understanding, hasn't cleared her account. The payment processing for their current account is completely separate.
Well, you don't need, honestly, that's not why we're here.
Yeah.
But what they're bringing it up for is the proposition that it's either retaliation or some kind of harassment.
That's exactly what I feel.
But the issue is that the law here applies, and I can't change that. The words on the page do say what they say. So what I'm gonna do is I'm gonna give you 90 days to figure something out, whether that's to obtain a waiver from them based on medical or financial conditions.
Why do we
They've
get it
told
from
you that you
them?
have the ability. I'm telling you have the ability. I'm not sure that they will, but that's one way of doing it. And then the other
go
is
to
to,
them.
I'm sorry, ma'am.
Excuse
The other
me.
is to connect. Now, I want to understand, in order to bring this into compliance, is that they need to pay a fee or that they need to connect?
They, at first.
Hold on, I'm not asking you. I'm ma'am, or sir, either one.
They would need to connect, sir.
So they would actually, it's not just a matter of, payment does not abate the
Yeah,
violation.
the ordinance that we're citing is the failure to connect to a central water system.
So how long does it take if they did choose? Doesn't sound like they will, but if they did choose to do that, how long would it normally take from payment to connection? Is that dependent on them?
So once payment is made, we have about a 2-week bubble that we can install a meter, and then the homeowner is responsible for the service line, which the county would need to see a permit for the
So
water
that's,
line ran.
that's not a 2-week thing.
Right, yeah.
Okay.
For us, we can install our side of it within 2 weeks. I'm not sure how long they would need to obtain the permit and actually connect the water.
Okay, so I changed my mind. I'll grant 150 days to figure something out on this, to give you enough time to do one of those two things. If it's not brought into compliance as ordered, a fine of $50 per day will be assessed.
I have one more question. Okay, she says connect. Is there a fee to connect? We have had no communication from them, so we don't even know if they'll charge for a meter or any of that.
They are going to charge for a meter.
And
It
how
says
much
so
is
in the
that?
letter, and
We don't have the letter.
you can get copies of everything that's here at this hearing, and I encourage you to take it up with them.
Well, 2005, that meter was installed, and the county commissioner said,
You're illegal.
violation.
You're
They
illegal.
hadn't removed the meter.
The word of a county commissioner in 2005 does not control over
Well,
the,
it should
over
be-
the
it should be.
statute.
That was our county
This hearing's
commissioner
over.
at that time.
Thank you.
Thank you.
Next case on the day's agenda, Hans and Karen Morvick, case number 2023.
Actually, before we
I'm
get to the
sorry.
next case, let
Did
me do two things. One is, I want to just put on the record that I think something the county might consider, because some of these hearings are taking longer than at least I would have expected, is to find out who of those who is present is not contesting a violation. If the county did find that out, we would be able to take those up, get those folks out of here. I don't know who those are, and this is just out of consideration for everyone's time.
Absolutely.
If we took a 10-minute recess, would the county be inclined to do something like that? I don't want to compel you to do
No,
anything.
Absolutely, if that'll make it, make us get out of here faster, absolutely.
And the second thing I would note is I do see Mr. Grant has shown up. Thank you. We did wait. Mr. Grant, do you know, actually, I do know this case. All right, so that might take a while as well. So
Right.
before we take up those cases, I'd like to see if we can figure something out.
Okay.
So does the county have any objection to that? All right, then it's 10:30. We'll take a 10-minute recess.
So my accent apparently.
Lori, who do we talk to about them turning the air conditioner off?
No one, I'm sweating.
I am so cold.
It's always a little nippy in here. I guess you could call facilities manager.
We have three of them. You're driving that car. Or flying that plane, I don't know what you're.
We were gonna be here. You know, these have taken longer and longer, the hearing.
The mics go hot.
Nice.
Julie? Here's what you got.
What we get.
Stars.
I got you. Let's do these first.
And then do.
No, so these two aren't contested.
Correct.
Okay. Where are they? Schultz, okay.
And look, if it doesn't end up resolving, we can just kick it or whatever. If it does, that's great.
We got two.
That's more than I expected. So, they do that at traffic ticket hearings. I've heard. I've never appeared, but they ask at the very beginning, you know, raise your hand, you can just pay the fine, we'll withhold.
Citation.
My daughter's a court reporter in New York for the traffic court.
They do that up there too. That's the way to get people in and out and, all right. All right, the time is 10:40 and we'll bring this hearing back into session. Has the county identified any cases for early resolution?
Yes, we have two. First case, Robert L. Schultz, case number 219-3396. Licensing Compliance Officer Timothy Williams, page 27 of your agenda. Expert on the case, Certified Building Official Sam Acosta.
All right, great.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name, sir.
Robert Schultz.
Thank you.
And could you both state your name on the record, please?
I'm sorry.
Timothy Williams.
And Sam Acosta.
Thank you. So my understanding, Mr. Scholl, is that you're not contesting the fact that a violation exists.
Correct.
Okay. And what is the county's recommendation on this case?
The Citrus County Code Compliance respectfully requests that the special master assess a fine of $100 a day, along with administration costs to be after the date of deemed sufficient to abate the violation. The amount was selected based on action of the property owners, and once they were advised of the violation, would also like the special master additionally define that the respondent's responsibility to contact the compliance division when the violation has been abated in order to allow for reinspection.
So, Mr. Scholl, how much time do you need to actually fix whatever this is?
Well, I submitted, all my permits are submitted. I'm waiting on them to come back.
Okay.
I have a number that I submitted them. But
Okay. Is that, I mean, to the best of your knowledge, is that accurate?
Yes, he does. He has applied for a building permit.
Is
So-
the application insufficient for any reason? Has it been reviewed? Do you know?
Not yet.
Okay.
They just applied for it.
How much time do you think it normally takes to review that?
What is the scope of work?
a home.
Oh, on the
Structure.
house?
The
We have a whole house in my place.
the shed.
Oh, it's just the shed, okay.
The shed turned into the house.
Okay,
Or-
if you give me the permit number when we're done here?
Yes.
I don't need a
If it's not-
precise, but you
Yeah,
don't need
yeah,
to give me a
2
precise
weeks,
number.
max.
So, okay.
Wait a minute. They told me they need a month to go through it.
No. So what I'm asking is just a general idea for my benefit.
Oh, okay.
And if it's 2 weeks, 4 weeks, I'm gonna give a little bit more time. I'm not gonna say just 2 weeks. Because
Okay.
it may be that they see things that, on the application, that are insufficient, okay? In other words, that maybe you need to go back and revise something, I don't know.
Okay. I want to say though that I've been doing that this whole last week, bringing it in. They tell me I need something else. I go get it.
Now you understand why I would give you more time.
Yeah.
So do you think that, does this abate when the permit is issued or when it's fixed?
When the permit is issued.
Okay. So what I'm gonna do, is there an immediate health, safety, sanitary concern?
No, sir.
Besides the fact that it's presumed to be unsafe without your approval?
Correct.
Okay.
No, there is not.
Then I will grant 2 months to bring this property into compliance.
Okay.
Does that sound fair? If it's not brought into compliance as ordered, a fine of $100 a day.
Okay.
Okay, thank you.
All right, thank you.
Next case, Warren B. Moreland, case number 2023.
You don't want this?
1365, Code Officer Brandon Norman, page 35 of your agenda.
Is that Mr. Westmoreland?
Yes, sir.
Okay, that's me, yeah.
Sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please state your name into the microphone.
I have no objection.
Okay, and what is your name for the record?
Warren B. Westmoreland.
Thank you, sir.
Yeah.
All right, so this is a case for a violation of section 20-31A. You're not contesting that there's junk debris. How much time do you need to comply?
I need about 45 days.
Okay. Is there anyone from the public who wants to be heard on this case? What's the county's recommendation?
I can say that Mr. Moreland has been in constant contact with me, unfortunately, as a tenant that will not allow him to bring the property back into compliance. I believe that's why he's asking for the time in order to
45 days?
affirmatively remove that tenant. The Citrus County Code Compliance Division respectfully requests that Special Master assess a fine of $50 per day, along with the administrative costs that, after the date that you deem sufficient to abate this violation, it will select based on the actions of the property owner once they are advised of the violation and relative to the severity of the violation. We'd also ask the Special Master to ask the respondent to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
Okay, I'm gonna find, based on the fact that you're not contesting that a violation exists, that a violation does exist, I'll grant you 60 days to bring the property into compliance, and if it's not brought into compliance as ordered, $50 per day fine. Okay?
I'm either gonna bring it into compliance next week, or I'm gonna evict those people.
Okay.
That's
Just
gonna
don't,
get resolved.
I don't think you're allowed to use a crowbar on them, so just nothing, we don't use violence here in Citrus County to resolve our problems, all right? Thank you.
Thank you, sir.
Next case, Edmund Trotter, case number 2023-00819, Code Officer Julie Wilkinson, page 29 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Julie Wilkinson, Citrus County Code Compliance Officer. This case was continued from last month. Mr. Trotter had said he was going to get an attorney and look over the evidences, but
Yes, I said that I would create, at his request, allow a new evidentiary record to be established. Is Mr. Trotter here?
no.
Okay. I do see members of the public who are here. I believe it's the same members who testified at the prior hearing. Now, let me just look at what I've done in this case. Okay. So this is a case where I actually found a violation, but there was a notice issue. I gave him an opportunity to keep the record and create his own record. He did not want to do that. So what I'm going to do is I'm going to incorporate all the prior hearings up to this point. And since he's not here, I think did I vacate the prior order?
I do not recall.
Do you have a copy of the prior order?
You did not vacate it.
Yeah, I don't think I vacated it. Do you have a copy of the prior order?
I may. Let me take a look. Yes, I do.
All right, can I see it, please? Sorry, thank you. All right, let me take a look at it. Okay, Ms. Wilkinson, would any of your testimony at the hearing today differ from your testimony at the December 2023 hearing?
No.
Okay. I'd like to hear from the members of the public and get their names on the record as well. Thank you. If you could come up to a podium and be sworn in.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Please state your names in the microphone.
Kimberly Hash.
Marshall Hash.
Would any of your testimony change from what was given at the December 2023 hearing in this case?
No, sir.
Okay, that's fine.
Do you have anything else to add?
Nope.
Okay, thank you. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $400 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master to additionally find the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
All right, so for the record, what happened in this case is that under the evidentiary record we had in December, there was sufficient evidence to determine that a violation occurred. However, the respondent did not receive the proper notice for the hearing. He was under the impression that it would occur in January. I issued an order to remedy any prejudice that Mr. Trotter would have had, and he indicated that he wanted to obtain an attorney. I continued the hearing to allow him that opportunity. That hearing was set for February. The evidentiary record is the same as it was from the original hearing, and Mr. Trotter has waived his the presentation of any evidence. So I'm going to go ahead and find that a violation has occurred. I'm going to sign a new order with a new time to comply, okay? And if it's not brought into compliance within 30 days, then a fine of $400 per day will accrue. Thank you.
Thank you.
Next case on today's agenda, Hans and Karen Morbick, case number 2023-01113. Code Officer Julie Wilkinson, page 20 of your agenda. Expert on the case, Samuel Costa, certified building official.
Actually, is it possible for us to take up the Aaron cases?
Thank you.
I mean, are there any other attorneys present? All right, so let's take up, well, is there a reason why not?
I'm just trying to get someone that's here out, because I know this was gonna be a long case.
Do you think this will be a
And,
long one,
you know,
Mr. Grant?
No,
I mean,
but I
they were running
appreciate it.
behind, and that wasn't, on the people
Let's
here.
see first, because I think there's other witnesses here for this case as well. We might be able to get more resolved.
Next case is on today's agenda. Jesse, Dustin, Aaron, case numbers 2023-00713, 218-2353, 2023-00730. Code Officer Brandon Norman, pages 5, 6, and 7 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
Mr. Allen, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Would you like me to present the fine appeal case first, or would you like
First,
to present it all together?
let me ask a question so I can understand. So there's
Understood.
3 cases here, and it appears that one of them I already issued an order on?
That's correct.
21-82-353.
So what is there an appeal of this?
Yes,
Was it timely filed?
yes, that's why we're here.
Okay, all right.
Your order was,
I don't remember.
subsequent order imposing fine.
Okay, and is that your understanding as well, Mr. Norman?
That's my understanding, yes.
Okay, so it was, okay. Would the county have any objection to taking the fine appeal up first?
No.
Okay. Then I'd like to turn to you to explain what the basis for the appeal is.
Thank you. When you had your hearing on June 21st, 2023, there was a discussion by you, by code, with my client regarding the resurrection or use of a fence to abate the issue. There were issues regarding vehicles and the like. By the way, I'm sorry, I'm leaning over.
If you need any assistance, let me know.
No, thank you. The fence was disclosed. The special master questioned the county regarding the use of the fence and the ordinance. Special master said it was a vague ordinance. Aaron put the fence up, and the fence was installed. The quintessential issue here to me, from my research, is the fence that Mr. Aaron actually erected ended up being another code issue, which is subject to, and frankly, there's no agricultural exemption on this, but there is on the budding property, but not for Mr. Aaron. So to me, it falls back to that the 16-foot fence that was actually a remedy, and that it was then in compliance to the extent of the violation that existed at that time, not the violation of the fence itself. And so I want to make that point to the special master.
And the point, just so I am clarifying and on the same page, is that the fence that is subject to one of the cases in front of me today was erected in order to remedy the prior case that we're here on the fine appeal.
Yes.
Okay.
And the issue under the case law that I've examined is that the adjudication on the 16-foot fence has not yet occurred.
It hasn't.
Right. And so my point is, as we sit here today, what happened was Mr. Norman then, in collusion with his neighbor, with Michael.
Collusion?
Yes.
That's
I'll
a little
get into
rough.
that and
That's a little
calls
rough.
the DCF and law enforcement later if I need to. But my point is to you.
Wait, what?
Yeah, exactly. I'll go through that if I need to when she comes up to testify.
I thought this was going to be quick.
It is. I have
okay.
like 3
all right.
questions.
All right.
Everything I have is supported and backed up.
Okay.
So my point to you is that I'm not going to be able to successfully contest the 16-foot fence. I can't do it. I tried. So to that extent, though, I want to make sure that the issue legally is that when it was actually done where he had rode by and he couldn't see it, there was a conversation that occurred. He went down the property line of the neighbor for the purpose of taking the photos. But the photos that he took, I appreciate, because there was an issue then under Florida Statute 320, because the issue was whether or not they were registered or whether or not they were debris or junk. And I think under the code, just so the court the special master is aware, these are off-road vehicles. They are not subject to registration. They are not subject to any, except the trailers. All the trailers have been registered. And then we have scrap receipts for many of the scrap that happened. So what's my point? I'm asking the court to place these all three together for an abatement period that I think is righteous. I think that we need 60 days, and I know this bleeds into the other one, but unfortunately, the only issue we're gonna have are the school buses that race at the Citrus County Speedway, the vehicles that race at the Speedway, but the trailers have all been registered. And so to that, I put that, I know it was kind of global.
No, so let me.
Because we could be done with this.
I think I understand what you're saying.
Yes, sir.
But sometimes things need to be explained to me like a kindergartner, as you'll find. So on the fence case, there's, the code section reads what it says. It's pretty clear. And you're really just asking for time to comply.
Yes, for all of them. But
Well, I understand, but just on this case, you are asking for time to comply.
On the appeal case, Judge?
No, on the fence, there's,
Yes.
the case number 2023-713, okay? And on the appeal, let me ask Mr. Norman this. So how much of a fine accrued on this case?
I couldn't even do the math.
So the property has been in violation from the order that you've given for 183 days at $50 a day. That totals $9,150 plus the $276.93 for the administrative fees, totaling $9,426.93.
Okay, so it's your position that the junk case number 218-2353 hasn't abated, correct?
That's unlicensed.
That's unlicensed inoperable vehicles.
Which,
Okay, so the unlicensed and operable
Or abandoned
vehicles.
unserviceable.
It's
Can
your
we say
ca-
which
it's-
case number you're looking at? I'm
I'm
sorry.
sorry, I'm looking at 218-2353, but I did,
Okay, thank you.
right, so the vehicle case, let's say, has not evaded.
That's
The
correct.
one where there's an order for me on it.
That's correct.
And I think what they've testified is they erected a fence in order to help abate that. Was that your understanding?
That's what he's explaining.
Okay.
That's what I understand from his explanation.
And just so the court knows, we don't agree that the violation we're talking about, that's why I want to know the case number. The vehicles are not required to be licensed.
Okay.
They're off-road. I have the Florida statute. I also can tell you that they're not abandoned, they're used, and I have racetrack officials here today to offer evidence if we need to.
See, this is a fine appeal.
Right, but the underlying premise is the same. I don't disagree. I've read chapter 162. It is a fine appeal, but the fine has to be based on, and I'm not drawing in.
No, I hear what you're saying. So what you're saying is that the property can't, it's already in compliance, is what you're saying, based on the vehicles.
Until the fence issue is resolved, yes. So
Now-
my point is, though, we're going to consent to tell you that we want time to find an alternative to that because the fence is 16 feet tall.
But the fence, let's assume there was a violation. Let's just arguendo, assume that there was a violation
Okay.
based on inoperable vehicles. Would a fence have abated that violation?
yes, because it would not have been able to be seen from the road. Because the vehicle, remember, there's different issues here on the ordinance. One is, it could not have been abated if the vehicles were unlicensed. Okay, but that presumes that they had to be licensed to begin
I
with.
get that issue, but I'm not talking about that. I'm saying assume that they did have to be licensed and they weren't.
Understood.
Or that they were inoperable.
Okay.
A fence doesn't abate that because it just says in the code section that it's a violation to store, place, or deposit them. Fence is irrelevant. So that's why I'm trying to understand the
Okay,
relationship.
I understand your
Okay,
question.
okay.
So the
okay.
answer now is, those are used at the Citrus County, they're not.
Okay, now I get your position. I get your
And
position.
I have the racetrack here, if necessary.
All right, so we don't really contest that the fence itself violates, but we do contest that the property itself really, that it isn't already in compliance because it's respondent's position that the vehicles that are there don't need to be licensed or are operable or are otherwise in compliance with section 20-41. And is there a position on case number 2023-730, which is the junk case? Mr. Grant, does your client have a position on whether or not a violation exists under the third case?
So this is, the answer is, these are materials and iron that he has stored there. He did pick up quite a bit and we scrapped quite a bit. The material that he's using, the iron and the steel, is actually what he does to build cages in the buses for safety and other things on the buses that are used for the racetrack to be able to comply. I'm here to tell you, at first glance, one would agree with Mr. Norman that it looks like it's debris until I start seeing all of the receipts and the work that goes into and my conversations with the Citrus Speedway. I think an accommodation here would be to give us 60 days in efforts to abate and then have Mr. Norman come out, and in efforts to, and also provide him information that might enlighten some of the issues under Florida Statute 320.01 that talks about vehicles that are run upon a track. Also, and I'll email this to Beth, and that registration is not required for any vehicle that does not operate on the roads of the state during the registration period, which is 320.02. And I only say that to the extent that on the Citrus Speedway, those buses crash, they speed, they're not on a roadway that's administered by the state of Florida. It's private property, actually it's public property owned by the county, leased to the.
Well, here's my concern, Mr. Grant. I like where you're headed, but the issue is, for me, I don't want to get into a situation where I give 60 days to comply on the two, setting aside the fine appeal, these two other cases, if there's not an agreement on what is not in compliance, if that makes sense. Because I think the county is likely going to have a different position than what you have. And I get what you're saying. Maybe there's an education, asymmetrical information issue here. But I think I would have to make that determination to get where we need to get. So I now understand Mr. Charlton's concerns. In any event, Mr. Grant, just so you know, he was just thinking that this was going to be a longer hearing. Mr. Norman, have you considered, I mean, on the fence case, I really don't think there's a lot to argue about here, okay? So what I really want to talk about is the junk case, and then we'll get to the fine appeal. Could you present your junk case, please?
Certainly. Brandon Norman, Citrus County Code Compliance Officer. This is going to be for case 2023-00730, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is for 13213 South Oakview Avenue, Floral City, Florida 34436. Property owner listed as Aaron Justin and Jesse Dustin. I have good service via correspondence with the representing attorney, and I would like to authenticate the following documents requested be admitted into evidence. Exhibit A will be photos taken during an inspection on August 22nd, 2023. A corrective action inspection done September 25th, 2023, and my final inspection done February 19th of 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the order to continue, as well as the correspondence between the attorney.
Did you say an order to continue? Oh, my order to continue
Your
based
order to
on Mr.
continue.
Grant's request. Okay.
Affirmative.
Which I appreciate, by the way.
All right, so Mr. Grant, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
Thank you. This is the fence you put up? Yeah. Oh, they're stapled, okay.
I assume there's members of the public who will wish to speak? Okay.
Now, these are the ones that were taken 8/22, right?
This is what I received from the 8/22.
Are these things?
Sir, could I just grab my water bottle real quick?
I'm sorry?
Can I grab my water?
Oh, of course.
Thank you.
Those are all gone.
That's all gone?
I mean, I still have some of the steel material, but the cars are all gone.
Okay.
And then that's a buffer for us.
Those trailers are all registered.
Those are trailers. Cars gone.
That's what you scrapped, right?
That's scrapped.
That's scrapped. Let's go to the February pictures. Let's see what we have, y'all.
Look, they're on the scrap trailer.
Yeah, they're on the trailer. Excellent. Let's go to February. Hold on, let me go to the first, February 19th. That's what that is. Okay. That's still there? No, that's just taken yesterday.
No, I took a copy because I bought it that way.
No, these pictures were taken yesterday. Oh, that looks much better. Trailers?
Yeah, trailers.
What is this?
It's an engine for a bus. Iron for the bus. Yeah. These are those bus tires and stuff. I've already got rid of my scrap tires. I took them to county and fired them.
Okay, so what was your question, Special Master?
Do you have any objection to these documents being evidence in this hearing?
No,
Okay.
other than we do want to query on the February 19th photos.
Fair enough. Mr. Norman, do you have a different set of exhibits for the fence case? Just curious.
All photos are taken on the same date for the fence case.
But they're not the same
They may-
photos.
They might vary. I didn't actually hear the response.
There are maybe some differences, so we're not getting there at this time.
Okay.
Okay, without objection, what's been proposed as Exhibits A and B in case number 2023-0073 are admitted as evidence. So tell me about this case.
Okay. On August 22nd, 2023, I conducted an inspection of the property for a compliance inspection ordered by the special master. It was determined that a fencing violation, a junk and debris violation now existed through the course of this inspection. During my inspection, I was met by the property owner. I informed him of the fencing violation. The fencing violation prohibited me from determining the compliance for the case 2182-353 due to my inspecting from the roadway. I informed the property owner that I would be completing my inspection from the adjacent property if I were able to obtain permission from the property owner in order to accurately complete my compliance inspection. I met with the occupant of the adjacent property who identified herself as the property owner for that parcel. I received permission from her to use her property for all inspections needed for my case.
And what was her name?
I don't have her name in front of me, I apologize. From the adjacent property, I was able to determine that the property was not in compliance regarding case 2182-353, as well as observing numerous piles of junk and debris in the rear of the property. The property remained in violation of my corrective action inspection done on September 25th, 2023, as well as my pre-hearing inspection conducted February 19th, 2024. I have had contact with the property owner, and we have discussed in great lengths the violations and how to come into compliance.
Have you spoken with Mr. Grant? Have you spoken with Mr. Grant?
I haven't spoken with Mr. Grant directly.
No. Now, on the picture from February 19th, I'm struggling to find the junk.
Could I show you?
Yeah.
Thank you.
Can we see which photo it is?
It's page for the record.
I don't have one of those. The only photos we were
It's the
provided.
only photo from February 19th I'm showing.
No, there's several photos.
Oh, okay, I'm
because
sorry.
There's several from 19.
Oh,
Special
okay,
Master.
I missed it, sorry. So there's others. So it's the red.
That's the doghouse.
Is that the only one? Is the dog a part of that? Okay, the bathtub. Is,
And I really need to be able to see what he's looking at.
I'll let you inspect it. I need to understand. So it's the red camper auto part. There's a tub by a container or fence? Okay. And the debris you're referring to is a green, black tarp? Okay. So let me.
Yeah.
There's debris on the back of a unenclosed trailer as well as tree debris in front of a abandoned RV.
Is that debris or overgrowth?
It's a mixture of both.
That abandoned RV has a tag on it, by the way.
And,
So it's not abandoned.
and this is,
Tree debris. That's all tree debris.
Tree debris.
There's debris located on these trailers as well as behind it. Again, a closer up shot of the open trailer. More debris in the wood line. More debris in the wood line.
all right, I get your case.
Thank you.
Thank you.
Well, can we give you ours now? With some cross-examination with that?
Let me just think about where we're at.
Because on February 19th, I would like to be able to comment just like he did on those photos.
No, of course you can. I'm just thinking about where we're at. And I want you to know where I'm at before you do that so that you'll know how to address my concerns. I feel like there's been improvement over the photos.
We've spent thousands of dollars in
Yeah.
scrap. You'll see on those photos, from some of those where the metal's actually on trailers, they're scrap trailers, where the material was moved out.
Well, let me tell you what I'm thinking, because I don't know, I doubt we'll be that far apart. I don't know, because you've already indicated a willingness to work with the county, but I want you to know where I'm at for the purposes of resolving this. So beginning on the photos of February 19th.
Yes, sir.
The first one shows a red camper auto part.
And the next one shows a dog,
Well,
because that's the
the
doghouse.
the second one is a close-up of the red auto part. The third one shows the dog and the tub.
The tub is referenced in a photo from a previous inspection as well. I can show you that if you
No,
need to.
I'm not concerned with that. So on page 4 of the February 19th photos, there's a tarp material.
The tarp material fell, that is correct.
Okay.
It's not
And-
debris, it needs to be put back up.
Okay. And on page
It is.
5 of the photos of the same day, I see materials in the back of an open trailer I see,
Okay, so I don't know which photo, but there is the material that might be used. Can you hold that up?
well, let me just run through it real quick,
All right.
and I'll give you the photos.
Yes, sir.
There's some vegetative matter and overgrowth that I think qualifies under the section as well. I see a very large mound of vegetative matter that if it was removed, it would simply abate it.
Hear that?
I do see
All
just
the
some
debris.
scattered, it looks like discarded materials on a large open bed trailer, wood, steel. Then a few photos later, there's one with, I guess, a stork or something like that, and
A what? What do you say?
a stork, I don't know,
Bird?
egret, I don't know.
I can't help the people who get my photos, sorry.
Again, some vegetative matter, again, some debris on the next page. So this is all to say, and I want you to have an opportunity to respond, but I do think all of this violates the code section. And I'd love to know, and I'll give you these photos if you want to do query
Well,
or
the moment
your
you
own.
said the vegetative, I don't have an argument for the
Okay.
vegetation.
Okay.
The other stuff is chassis to a bus, steel, wood material used for what they do.
And let me tell you, I've thought about that. I've thought about the fact that these things can be used for what has been represented
Great efforts
here.
have been made to remove all the scrap that Mr. Norman had previously
I
identified.
still see some, and in the code section, I reviewed it before going into this. It does talk about, like, section 20-31, okay? It's unlawful for the owner or occupant of any land to permit, cause, or have thereon any accumulation of junk, debris, rubbish, and vegetative matter, except junk stored in enclosed litter receptacles, junk which will not fit in standard size litter receptacles, but which is set out for no more than 48 hours, et cetera, et cetera. I don't think any of the other exceptions apply here. My concern with this is that, look, if it was all in a garage, like a big garage, I doubt that would be an issue here. But it's all out in the yard, and even though it can be used, that doesn't mean that it isn't under this definition, the definition of junk and debris, which I'll turn to. Junk shall mean any abandoned property, construction and demolition debris, litter, waste materials of any kind, used or unserviceable automobile. Or, in other words, it's not just that it has to be unserviceable. If it's a used automobile part, then that is actually considered junk under this definition, whether I like it or not. It's broad and.
What section are you reading?
Section 20-3, the definition of junk. It says used automobile or machinery parts qualify. It says used or non-functional furniture, used and non-functional tools, equipment, implements. It doesn't include compost piles, okay? But I don't, this is why I'm struggling with this. This is why I think just looking at the evidence, I would find a violation. I'd be happy to grant 60 days. I would grant more, but but those would be my findings without hearing more from you. So you could just take the order and run, or you could try to convince me that these things are not junk. Do you see what I'm saying?
We'd have to bifurcate, because I don't disagree with the vegetation. Every single vehicle in the world that ever landed on that property would be used.
Yes.
Unless it was manufactured on his property.
Correct.
So I'm going to leave that and say to you that as to the vegetation, if I can see those photos and have them pointed to me, I can very quickly resolve this.
If it's just the vegetation.
Or if there's something that I missed, like they said, the tarp fell down, it's really not
Yeah.
debris, we'll put that back up.
Well, it is debris. It just becomes not debris if it's.
The day he came out,
Yeah.
my client didn't even know it had fallen.
Well, here's the thing. I agree with the county on all of its contentions about what constitutes junk without having heard more. So I want to give you an opportunity if you want to argue it and contest it.
Well, let me ask you this question. Is the special master inclined to clump these three things together and give us an abatement here?
I am And so, setting aside the fine appeal just for the moment, if I was setting that aside, I would look at the junkyard conditions, the two other cases,
Yes.
and be happy to grant an abatement period of
May I
9.
have a moment?
Yeah.
Does this, for 90 days, we would consent.
Okay.
For a minimum 90-day period to abate this, bring Mr. Norman back out, involve him with the people from the racetrack and negotiate with him what he thinks needs to happen.
I mean,
Okay?
that's what I would do. I would leave it in Mr. Norman's discretion based on my findings today. Okay? Does the county have an objection to me issuing an order on those two cases right now and then dealing with the fine appeal?
Finding that there's a violation and giving them 90 days to.
In both cases?
No objection.
Okay. Then what is the county's specific recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master.
And I'll need to hear from the public, just to be clear. But go
Assess a
ahead.
fine of $150 per day for each violation, along with the administrative costs for each case, to begin after the date that you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violation, and this amount is appropriate given the severity of the violations as well as the respondent's actions relative to these violations. We would also ask that the special master find its respondent's responsibility to contact the Code Compliance Division once the violations have been abated in order to allow for reinspection.
Now, I would like to,
When it's appropriate, before your ruling. I want to be heard.
Okay.
Thank you.
I do, the reason why I announce where I'm going with this is so that the public has that benefit before they come up to speak. I would like to invite members of the public to come up and let me know their input or opinions. Ma'am?
This is the one that called DCF.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name.
Samantha Foster.
Thank you.
Thank you. Welcome back.
Well, thank you. Let me just start by saying that the Aarons were like family to us. We have children of all the same ages. There would be many nights where little Roman, 3 years old, would, run across the street and walk into our house with a slice of pizza in his hand, and we just had a really tight bond. So it saddens me to stand here today. My daughter, about 2 years ago, she's now 12, she broke her leg in 3 places on their property. On one of the, let's say, 12 to 15 buses they had in the backyard. To this day, I brought, all the referrals that I have from doctors.
I heard there's a good injury lawyer out of Inverness who might
Well,
be
you know
willing
what?
to-
I actually tried going to his firm, but for a dog bite case.
Sorry, I didn't mean to open up a can of
Yeah.
worms. But okay.
But I did not know that he was already representing the Aarons. This was about 1.5 years ago, too.
Okay.
So after the first, this is now the third one. Yes, my daughter has missed roughly about 50 days in the last 1.5 years due to this injury. She broke her growth plate and it splintered right up her leg. We still were friends after that. Sheena Aaron apologized for not closely watching the kids because they are not allowed in that area due to the, as she stated, junk and debris. So, yeah, like I said, with the junk and debris, but they were nice enough, we didn't have a shed for our goats, and they were nice enough to give us the last 3 seats of one of their buses, and we have it in the far corner of one of our pastures that no one can see, but we have built actually walls up around it. and, you know, climbing apparatuses for our goats. But, so the junk and debris, yes, that's an issue, but I know they have been trying to clean it up, and the only reason why I know that is because on the 14th I was severely attacked by their dog for the third time. I had to have the sheriffs. I was on the phone with 911 while it happened, but when Animal Control had me walk down the fence line to find out where this dog kept getting out, and the workers at that residence showed Animal Control where the dog keeps getting out. Saw that, you know, the yard was still clean, was getting cleaned, but there's still several things back there. And I just found out from Mr. Carlton yesterday that this hearing was today, so I was not very prepared. They like to do their work starting at 11 o'clock at night. They bring in tractors off from down the road, you know, and they just do, and they shine his tractor light right at all my cameras. So, you know, we can't really get actual footage of it, but I have tons of footage of all of the stuff going on. I mean, I was just sitting back there taking screenshots of everything. But now to the fence. Well, one, junk and debris had to take my house off the market because, you know, no one wants to look at that when they're buying a house for $650,000. So, but, you know, that's why I moved to Citrus County for, you know, freedom and choice of where you live and how you proceed to have your property. So whatever, if you don't want to buy my house because of what my neighbor's property looks like, oh well. But the fencing, the black fencing up against the road is, even the bus department said it's a safety concern. And why I filed the complaint on the fencing, I got so mad because I have spent over $6,000 in vet bills. I have screenshots of the conversation between his wife and Mr. Aaron on all of the times that their one dog attacked me, got onto my property, killed 2 chickens, ripped them apart, has attacked me 3 times at the bus stops. Like, this is all at bus stop time. So just on the 14th, my 6-year-old and 4-year-old, now 5-year-old, crying, you know. But I don't even know what became of that. But I had to put down myself, my service dog, Bear, because he was so brutally attacked through the fencing. I was told to put up the barbed wire at the bottom of my fence after that happened to stop their dogs from getting hurt.
Was this the code violation
yes.
we had?
So
Okay.
their dog, right when they filed the complaint on my barbed wire, was because their dog actually got, I guess, too close to that barbed wire. So it got maybe cut, hurt, I don't know, I don't really care. But it's sad now that after, you know, Animal Control was there on the 14th, advised me that I need to carry a gun down to the bus stop. But yes, I had to put down my service dog due to injury. I have pictures of my Plot Hound, who was only a year and so many months old, who will never be able to walk right again. He's 2 now. And he had to get 80 stitches in the back of his head, neck, and his leg got caught in the fence while their pit bull Hank latched on to 3 different sections and crushed his leg and severed a nerve, and his paw was stuck up like that. This was never reported, even me carrying in a 90-pound pit bull and wrapped completely up myself from the pit bull attacking me and my pit bull, because their vet, he builds the engines for the vet.
Well, let me ask you this. I just want to make sure I understand the relevance. This is about the fence.
This is about the fence. I got very angry when I saw that fence being eradicated, you know, the out of telephone poles at 12 o'clock at night. And why couldn't they build this and put it all the way around to keep their vicious dogs from having me to put down 2 dogs?
I see.
You understand what I'm saying?
I see.
The wood part of the fence does not even bother me. But then when they attached, You know, I don't know how tall the wood was. I'm assuming probably about 15 feet. And then they put another 13 feet on top of that with the vinyl fencing, but then the black vinyl fencing that is now on the street. It's
Well,
just,
the fence is in violation of the code, and
I
they've agreed to
understand.
take it.
I understand, but the junk and debris is not gone. And, you know, just, I want to know, one, is the property considered commercial? Two, is he Citrus County Speedway's storage lot? That's, I mean, I'm sitting here listening, Citrus County Speedway, Citrus County Speedway. What, does he keep all of the race cars for all of the drivers there? Or does he keep all of the buses for all of the drivers there? Because he only races 1 or 2 buses. Does he get, like, for all of the landscaping trailers that he keeps there for landscaping companies? Like, I understand he builds engines, but is he, you know, commercial to be able to keep all of this stuff there?
Here's what those questions are not for me to answer. I understand you having those concerns, but also we've resolved that. I mean, we found a violation there as well. So I guess what I'm curious about is, do you have any other input about, you know, anything else on the cases? Because I can't answer those questions.
I understand. I'm just, I know there's a witness here from Citrus County Speedway, so I'm just trying to, you know, implement maybe some questions that need to be brought up. Yeah, I just want to state that I did walk the property line with permission of the workers. Workers did state, you know, their fence is basically down on the one side, but they're eradicating all these other fences to, you know, hide.
You mean
know, the
erecting?
junk, yeah,
Okay.
erect. Yeah, I'm sorry. I am on a very strong dose of antibiotics because I had a lot of bites in this hand. So, anyway, all right. Well, that is all I have to say. I'm sure there's probably more, and I know when I get home, I'm going to think of a million more things I should have said. But I just wish they could keep their dogs in their yard because I don't want to have to, you know, shoot a dog at a bus stop. It's pretty detrimental to my children to see their mom attacked 3 times now. So
Thank you,
they
ma'am.
need to keep their dogs locked up. Thank you.
Well, you do have the opportunity to respond if you feel the need.
Yeah, I do feel the need, because it's ridiculous. Animal control has documented this very well. If there's been no issues with Citrus County Sheriff's Department animal control and whatnot. So I don't know about the issue about the gun comments and whatnot, but as far as that goes, I just want to be real clear that that has not been the case with animal control.
Okay.
And so, listen, I really appreciate, I was quiet when she spoke.
Yep.
So, but I want to make sure the court, the special master knows that basically what I gleaned from that conversation with her, or comment, was that it was.
Ma'am, you had an opportunity for comment. No, I understand, but
Listen. You want me to stop, or you want her to
no,
just run her mouth?
it's your time to respond.
Okay, thank
I don't
you.
think you need to, but if you
Okay,
wish,
well, I just
you
want
have
to
that
point
right.
out the 2 comments regarding that they were trying to clean it up, that she visualized them making those efforts,
Okay.
and that the fence was up.
Well, look, I think that I take the public's input on this. I do feel that it's relevant, but I also feel that y'all are essentially not contesting the cases, these 2 cases, and are agreeing to bring it into compliance. The goal of code compliance is compliance. The dog issue is just not a matter for the code case. I'm sorry, Mr. Norman.
When you have a moment, I just need to put one thing on the record in regards to the fence case.
Go ahead.
In regards to the fence case, I just wanted to be aware and on record that, for one, it's improper material and it's the improper height. That's what we're asking to be brought into compliance. Does that be made?
Personally, I think that's clear, but
Yeah, I just
is
wanted
that
to make sure that
understood?
it was on record,
No,
because I didn't
thank
get a
you.
chance to
I
present
think
the actual
material
case, so.
is vague, but as to the
Well-
height, we're not going to disagree
Okay.
with the violation.
You're going to work with Mr. Norman, in other words,
Yes.
to bring it into compliance.
Yeah.
All right,
Thank you
so
for
what I'm
that.
going to do is I'm going to issue an order finding that a violation has occurred in each of these cases, that 90 days is granted to bring them both into compliance, and if they're not brought into compliance, if either one is not brought into
Well,
compliance.
I did want to make comment regarding the fine.
Okay.
before you go.
Well, you might as well.
Okay, so as I heard it, he was requesting $150 each. I believe that in the aggregate, that's $300.
Correct.
I think it'd be appropriate for $50. In the aggregate would be $100 a day. That's what the court found, the special master found last time. There have been substantial efforts to clean up this property from the photos that were taken in August to the photos that were taken in February. So I'd like the court to consider
I
that.
appreciate that point. I'll find that if it's not brought into compliance as ordered, a fine of $100 per day in each case will be assessed.
Okay, thank you.
Now let's go to the fine appeal.
Might I respond?
Of course.
On the fine appeal?
Yeah.
They're basically trying to contest your findings that a violation existed, and since they did not file an appeal to the circuit court, they cannot use this fine appeal case to contest those issues. And I'd like to cite Verity versus Metropolitan Dade County.
What is that course?
My computer just shut down, so I'm gonna have to get it.
What do you think that case says?
It says that you cannot use a fine appeal to attack the findings
Well, let's just
of
look.
a violation.
Let's look very quick. You had pointed out to me the admin. Let me look at that admin rule again. Okay, a request for release shall not be accepted if, among other reasons, the request is incomplete, the violation has not abated, relief is sought for a repeat violation, the property owner did not use his or her best reasonable efforts under the circumstances, and the amount of administrative costs has not been paid in full. A doesn't apply, the request is complete. I think what they're making the case is under section B, regarding that the violation has not abated, because they're saying it's not that it can't abate, it wasn't a violation in the first place.
That's correct, and they can't make that argument under the Verity case.
I'm not sure I understand what you're indicating. We're saying that the effort to abate was the fence, and the fence was erected.
Okay, so you're saying,
Timely.
actually, it's subsection D, which is the property owner did use best reasonable efforts to abate the violation.
And then later, Mr. Norman came out and indicated at that point that the fence was not in compliance.
Yeah, that's, I mean, I've already made a finding that a fence out of compliance was made in good faith earlier this morning, so it's your lucky day on that point.
Except that in your findings, it was spelled out. They had to be either completely out of view, or they had to be in an enclosed structure. This is the school buses. Or they had to be registered. And they were not completely out of view. The fence that was erected did not shield the view.
Do you have a copy of my order?
Yes, I do.
And so do I. But I want to make the point that Ms. Antrim is making. The issue is the school buses that are in violation. Not school buses that did not require to be registered under 320.01 and 02. They are off track. They are not used upon the roads of the state of Florida. They're not required to be registered.
Okay.
Or licensed.
All right, let me look at
And
this.
that's where he's attacking the findings of the special master. And the Verity citation is 684 Southern 2nd 870.
I'm sorry, can you repeat that?
684 Southern 2nd 870. It's a 3rd District Court decision.
All right, let me just look at my prior order. Because these are just masterpieces of authorship.
I have exhibits as well for photos.
I just want to see what I said. All right.
On your,
Mhm.
what you were talking.
You want to direct me to something?
Only to the extent that the, indicated that the cars and buses, vehicles brings to the Citrus County Speedway, that was testified to, you accepted that.
Mhm. Yeah, I have no reason to disbelieve that.
And if these vehicles are used for driving around the racetrack and having collisions, then I believe they would fall under the disabled motor vehicle provision of 320.01 subsection 37, disabled motor vehicles, any motor vehicle unsafe for operation on highways of the state, which brings them directly into the purview of section 20-41, which they were cited for, which makes it illegal for them to keep, dump, store, place, or deposit abandoned, unlicensed, inoperable, junked, disabled, wrecked, discarded, or otherwise unused vehicles on any property.
Here's what I'm inclined to do.
I disagree with that 1,000%.
And because you do, and this is a matter of first impression for me, I'm gonna issue a briefing order on this.
I object because he can't contest the findings that were.
I don't know that I'm going to make an issue about the findings. I think there's a legal question here. And I think the legal question is whether or not, there's a couple things. I agree, I'm not going to revisit the findings, and I'm not going to allow the augmentation of the evidentiary record. But you've just cited several statutes that I don't know or understand, and so has he. So I need to read this. I'm not prepared to issue a ruling on it today. You may very well be right. I don't understand these statutes, so I'm not prepared to make a ruling today.
Even if the
And I
buses
would
were
say
in
the
question, they're still,
Excuse me.
I apologize.
I would say that the statutes are irrelevant. We have a special master's decision that's made specific findings that there was a violation. It was not appealed, and it cannot be contested at this point through a
Well,
finding.
I also want to review that case that you cited, because I just haven't had an opportunity to review the case. I don't have a copy of it. You may be right, but I just don't know.
Can we approach, please, Ms. Antrim and I, regarding the briefing order?
Well, I don't have a,
We may, just for a brief moment.
I'm going to reserve ruling on the fine appeal, and I may or may not issue an order. I expect to issue a briefing order. If I do not issue a briefing order, I'll reset this to issue a denial.
Thank you.
Okay.
Thank you.
Next case on the day's agenda,
May I be excused?
Yes, please. Thank you for coming.
Hans and Karen Morbick, case number 2023-01113. Code Officer Julie Wilkinson, page 20 of your agenda. Expert on the case, certified building official Samuel Costa.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Please state your name.
Karen Morbeck.
Thank you.
Thank you, and good morning.
Good morning.
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 23-01113. Buildings and Building Regulations, Chapter 18, Article 1, Section 18.8A of the Citrus County Code Ordinances. The address is 1510 South Trellis Drive, Homosassa. Property owners Hans and Karen Morbeck. Have good service via signed certified mail return receipt. I would like to authenticate the following documents and requests they be admitted into evidence. Exhibit A, photos taken during initial inspection on November 28th, 2023. Photos from a corrective action inspection on January 10th, 2024. Photos from my final inspection conducted on February 20th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
Yeah, like, do you think this is a picture of your property? Like, I didn't alter it or anything?
Are you contesting that there was construction without a valid permit?
No.
Okay. How much time do you need to fix it? I mean, Ms. Morbeck, how much time do you need to fix it, if that's the case?
Well, we did apply for a permit for a demolition of a mobile home.
Okay.
And
Will that fix the
it has-
problem?
It's already been done, and the
Oh.
permit is closed.
Okay. And that hasn't abated the violation? Okay, all right.
All right. So this is what we're here for, is this.
Yes, ma'am.
Okay. So. Only this bill. This is what we're, all right. So what am I supposed to say here?
You just answer any questions that he has.
Okay.
I think, Ms. Spiros, I'm going to amend the pre-hearing order to talk about pre-hearing resolutions. Okay. Without objection, what's been proposed, you don't have any objection to these documents?
No.
Okay. Then what's been proposed as Exhibits A and B are admitted.
So on November 28th, I conducted an initial inspection and observed a mobile home in the process of demolition, as well as a second mobile home on the property. Research was conducted and found that no demo permit had been issued, and there was no permit for the second mobile home. On November 8th, 2023, a notice of violation was issued for an after the fact, which is a violation of Citrus County Code of Ordinances. On November 27th, I found that the after the fact demo permit had been issued. However, no permit for the second mobile home had been issued yet. So I had contact with the property owners. They're very courteous and friendly and have shown a willingness to comply with everything. However, as of February 20th, 2024, the property remains in violation with no permit being issued for the second mobile home, which remains on the property. My expert on this case is Building Director Samuel Costa.
Okay, so there would be a permit required for that structure.
Okay. And does this make sense to you, ma'am? And by the way, who
all in
are you
all, yeah, it
supporting?
does
in-
make sense. I was just-
Ma'am, hey, who are you supporting in 2024? I don't know if I can tell. But go ahead. I mean, so this seems pretty simple. I mean, are you?
Right, I just have to apply for a permit, I guess.
And get it.
Right, now, and my question is, the building in question that does require the permit, does it need a title to permit it?
Which one?
For the second mobile home.
Oh, yeah, yeah.
And,
Who installed it? Because that has to be installed by a licensed mobile home installer.
that building has been on the property for like 15 years, as far as I know. I
You're
just
saying a
purchased-
title would be necessary to get a demolition permit on this?
Well,
That is not, yeah, I wouldn't know.
if we moved the mobile home to the location of the demoed mobile home,
That's creative. I doubt it. I mean, I don't know. Does that somehow, I mean, why would that abate the violation? It's still something that needs
It
to
would
be.
still have to be permitted.
Yeah.
right, you're right, I understand that, I'm not questioning the permit,
Yeah.
I'm questioning how to get the permit.
To relocate a mobile home, the work has to be performed by someone who is a licensed mobile home installer.
So my first step would be to see whether the mobile home was structurally sound.
The mobile home installer would know what documents he needs to submit. Whether it's structurally sound or not it's not my concern. You're the one doing it.
So I just need to get a,
No, and
Actually-
let me take this back. So what I want to understand is, what does she need to abate? She needs either a permit to demolish it, or what? To move
The
it?
one
To-
was demolished, wasn't it?
Yes, there
Yeah.
was one that was already demolished, which they did.
So how do we abate this?
Okay. It's my understanding she either needs to have the mobile removed from the property or have it permitted.
Okay.
How she gets it permitted, I have to refer to my expert here.
Yeah, okay. All right, so I was just under the impression it had to be demolished. Doesn't have to be demolished, it just needs a permit to either be there or moved.
Correct.
All right, now, ma'am, basically what it comes on to me is, because I do find that there's a violation, is I need to give you a reasonable amount of time to do one of those two things. And how much time do you think you'll need to either move it or get it permitted?
well, in order to get it permitted, it has to have a title, correct?
Not that I'm aware of. The
Not that
title
you're-
is to
just
drag
to
it down the
permit
road.
it.
It's my understanding. The title is to have it on the highways.
Oh, is that what it is?
Look, I don't want to get into that, and no
Yeah,
one's
yeah.
going to give legal advice here, but here's the thing. Let's say that you do need a title and you can't get the title, then
Right.
you have to move it. So I just need to know what amount of time you either need to get it permitted or to move it.
Well, I guess 30 days to permit it. If I don't need any paperwork,
I mean, I don't
I
know
would
the
think a
answer.
month should be sufficient, correct? But if paperwork were involved,
Yeah, God knows.
right, I mean,
So-
the mobile home is anywhere between a 71 and a 74.
Okay.
So,
Well, look, I don't think this is very complicated. Either you, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they revised this violation. We'd also ask the special master additionally find that it's respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
What I'm gonna do is I'm gonna grant 2 months to bring the property into compliance, either to obtain the permit or to remove it. If it's not brought into compliance as ordered, what was your fine recommendation?
$50 a day.
$50 per day will be assessed, okay?
okay, so I have 60 days to either get a permit or,
To abate the violation, and so you can do that by getting the permit or by removing it,
okay,
okay? Thank you.
thank you.
Next case, G Research and Analysis Limited Liability Company, case number 2023-00662. Licensing Compliance Officer Keith Gardner, page 14 of your agenda. Expert on the case, certified building official Samuel Costa.
Page 14?
Good morning.
Yeah.
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the
Yes.
truth, so help you?
Yes.
Please state your name.
Serge Platitz.
Thank you.
I'm an individual defendant over here according to the paperwork.
Good morning.
Randall Garner, Citrus County License Compliance Officer, case number CE 2023-00662, Article 1, Chapter 18, Article 1, Section 18A, obtain after-the-fact permit for all construction and modifications of the Citrus County Code of Ordinances. Address is 9632 West Plantation Lane, Crystal River, 34429. Property owner Sergei Pilatus. Good service via posting at the property of the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on August 11th, 2023. Photos taken at my follow-up inspection on September 11th, 2023. Photos taken at a corrective action inspection on January 4th, 2024. And my pre-hearing inspection photo taken at February 20th, 2024. Exhibit B, a copy of the notice of violation, a copy of notice of the hearing, copy of the pre-hearing order, and a copy of the posting affidavit.
Okay. Sir, I think you know how this goes. I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence here.
That's true. But that picture we're taking when I put the stuff, which technically it's a brand new stuff, purchased in the store, brand new. I was moving the stuff inside of the particular rented stuff. And when the officer asked me what I'm doing, I showed them that I'm moving the stuff which not fit the property into the storage container.
Well, Mr. Plotitz, I have a hard time imagining, because I haven't seen the photos, so I don't even know what I have no idea what they're claiming, to be honest.
Yeah, I know.
Let me just take a look at these.
Give me 1 second, I'll pick up my phone to show
Yeah,
you.
of course, yeah. All right, then, I'm gonna look through these exhibits very quickly.
I'm allowed to show you the picture today?
I'm just, yeah, you'll get, so I let them present the case first, just because I need to understand what they're
Yeah, I
claiming.
do admit I was taking brand new stuff at the time, when I was taking the stuff from the property into the shipping
All right.
containers,
All right.
rented.
Well, so I'll admit these as evidence, and tell me what's going on, Mr. Garner.
Okay, on August 11th, 2023, an inspection was conducted at 9632 Plantation Lane, and photos were taken of the shipping container being used as storage. My follow-up inspection on September 11th showed 2 more containers that had been placed in the front yard. And I spoke to Mr. Pilatus and let him know that made him aware that the containers could not stay in the yard, that they need to be removed. And my expert witnesses, as of February 21 at 8 a.m., no building permits have been applied or issued. My expert witnesses are the building official, Sam Acosta, and Land Development Director, Joanna Coutu.
Okay.
Yes.
Regardless of applying for a permit, you can't get a permit for these. The Land Development Code prohibits storage containers to be used for residential storage.
Okay, so the Land Development Code prohibits storage containers from being, like, on the property?
Used as residential storage, yeah.
Used as residential storage, like, on a temporary basis as well?
There is a provision, if you have a house under construction for a period of time, you can have that while it's an active building permit, but that's it. It's outright.
This is open permit, by the way.
And I want to be clear, so just as I frame it in my head, so there's not a prohibition on them using containers, there's a prohibition on them using storage containers on a residential lot.
As storage.
As storage.
Right.
Like okay.
So there kind of is against using the containers on the residential lot, yes.
Unless it's as part of a construction
Part
or
of
a
an
permit
active
or-
construction site, and even that's limited, yes.
So let me,
This is actually a recent amendment, it just occurred.
okay, that's what I was gonna say, I don't understand.
If I may approach, I have the recent amendment, it's 3102.
3102,
It just occurred, I believe it was in November,
okay,
and it applies to residential.
all right, thanks. Maybe it is in here, I don't know.
It should be in
Yeah,
I didn't know if you
I
kept
noted- yeah,
up
it
to
is
date
in
you
here,
kept
so
them,
let me
so I
just-
didn't want to make sure she had that. You're on top of it, Lori, good job.
so Mr. Plottis, this is new to me too. Let me just take a moment to look, it's
May I say-
3102?
May I say something before you take a look?
Okay.
At the time, I had open permit for the roof.
Mhm.
I came to the property, as they told me, you have to make a note that you have a storage container. I did. Then I went to the county, I said, my windows permit is gonna be open. And I have to take everything from the house until the job will be done. They told me there is no permit for renting. If you build something, you have to do it. That's why I applied for all search and every permit. And I went to the company that told me for the renting, it's like you have a renting vehicle. You put it in a property lot. It's not prohibited. I was trying to get a permit, and this matter became as a court hearing with Honorable Judge Hain, and he asked me to apply for the permit. And did everything possible to comply with, because, like I said, this is for temporary stuff and roll, out. And all materials are size, specifically with after the hurricane and tornado, it not suit the house by no means. So I was trying to get a permit, I was not able to. I was with the code enforcement
Mr.
people.
Potts,
It
here's
was
the
a-
thing,
yeah.
I still don't understand what the county's case is.
I
Ms.
understand.
Harrison, I lied, I thought it was here. It's not. You did update some of the pages, but for whatever reason, those specific pages are not here. Thank you. There's a bunch of November 28th, 2023 in here. It all is, except for the first, exactly what I'm looking for. So
They are all rental.
well, let me just see here. So special
didn't do it.
requirements for all accessory uses. Let me look at something.
Okay, I keep, for some reason I thought more red was. If I do that one, I should be quick, because then that'll get Sam out. She just asked me again, I'll do it. She just asked me, that's what Julie was.
Okay, so let me see if I understand the county's case. So under section 18-8 sub A, it says no person shall ... change the use or occupancy without first having obtained a permit, therefore. So that's the case that the county's presenting.
Correct.
And now, since you issued the notice of violation, you've actually amended the code to say you can't put these kinds of containers on the property anyways. So it's not possible to get a permit for this?
No, it's not.
I did try everything what was possible, everything. I went over here, I went to the code compliance people. They walked me to the permit section. They told me, unless you build it, you need a permit. For the temporary was open permit, because at that time permit was open, and still now the permit is open. At all relevant time and frame, like a TPO, it was open permit.
And at the time of the violation, there was an ability
it
to
was.
apply. Now there's not.
It was, because at the time when it was inspection for the roof, I specifically came to the building department. You were not there, ma'am. I was. And the code compliance officer walked me in, and she told me, unless somebody make a complaint, there is no case. And I have a retaliatory guy who is doing it, and I have a sheriff report, but it's not the story. It's relevant, but it's not affected. I went and applied for the permit. I was denied.
When did you apply?
I went before I even applied for the window, because the contractor does the windows.
Was that before September of 2023?
Yes.
Mhm.
And actually, I was told that I might have a container if I need it for the open roof and other stuff.
Well,
I would do everything possible.
So what is the county requesting here?
I would like, if the county gives me the permit, I would more than glad to.
That's not gonna happen.
Yeah, but they
yeah,
they rejected already.
Let me understand. So what is the county requesting here?
Citrus County Code Compliance Division respectfully requests the special master assess a fine of $100 per day along with administrative costs being after the date you deem sufficient to abate this violation. The amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We'd also like to, would also ask the special master additionally that it is the responsibility of the respondent to contact the License Compliance Division and when the violation is abated in order to allow for reinspection. And I do have one more thing to say. The
Okay,
permit,
I'm agonizing about something. Go ahead.
okay, the permit that he is stating about was, the only thing that he had open at the time was for windows. And when I spoke to Mr. Acosta, he said that's not enough to be a construction storage, and his permit is expired on 12/27 of 2023, and the windows have not been installed.
I mean, I guess it's just, how did he change the use? How did he change the use of the property? Nothing changed,
It's
nothing
storage.
changed,
He's using it for storage with the containers.
but it's still a residential. Well, Mr. Platts, do you live there? Or is it rented? Is it rented?
It was supposed to be repaired. It don't have a contract to sell the property already.
It's vacant.
It's vacant.
Okay.
And I can tell you something else. It is residential. I stay like for the weekends over there, but still all the time. It's my residential as well, because A and B is another gray area. You can stay on the property and live over there.
So,
But
here's the thing, so what if he put a, what if he put a park bench in the front yard? Does that change the use?
I can state for that.
I may say something.
I'm not asking you.
Yeah,
No, yeah, I'm throwing it out to the county. Here's why I'm asking. When you have a vacant parcel and there's no principal use established, you're not allowed to use it for storage. And we have in our cases interpreted that very broadly. If you have a park bench, we have found that is a violation without the principal use being there. It was used for storage is the idea, or just placing something there. But once the principal use is established, that is always considered okay. Oh, I mean, as far as I know. So I'm trying to understand how under this code section, putting something else on the property when the principal use is established changes the use of the property. Is what I'm asking making sense?
I understand you're saying by him adding the storage,
Correct.
change the use of
It
the.
doesn't change the principal use. It could arguably be adding a use, it adds a use.
Correct.
Does that qualify as a change under this code section? I don't know. I'm not bothered about the fact that the law changed and all that stuff, and frankly, we can give a time to comply, he'll do it, there won't be a penalty, there's no prejudice. But I'm wondering if there isn't a better code section for you to bring this under.
I see.
And I probably am not the only one. Go ahead.
It is my residential address from the beginning. Because of the business loan, okay, the company who give me the loan actually make me put the property as a collateral. That's how the jury search was actually afforded for. I stay there, it's my residential living. Now, when I did apply for the permit and the officer did call to the windows company, so you have to take everything out to make absolutely clean. But then the hurricane and that stuff, the water came into the house. Anyway, this is a residential house. I did try to apply, and I was asking to issue me the permit. And by the way, the permission for this permit was even had in the file with the windows. They didn't have any objection. I was asking that. It's if you open the file, you can see that.
Well, Mr. Plotz, I don't know if this is, honestly, I don't, I'm not persuaded by those arguments.
I understand.
I'd like to ask the county, is there another code section that the county could have brought this case under? I believe there is, but is the county aware of one?
Not aware of right now. Not aware of right now.
The time that it was done,
Right.
I'm not sure. Give me a second.
Yeah, sure. Yeah.
Because you're kind of asking us to kind of come up with something real quick, but in my quick analysis, I'm like, okay, what are the setbacks? It sounds like he applied for a permit. The permit was denied. I don't know why the permit, but again, I'm trying to piecemeal based on the testimony
And-
that they're giving me. It sounds like he applied for a permit. It was denied. It would have been denied for a reason. I don't have that information in front of me to provide to the court. So if there was a permit that you could have applied for, it was denied. It shouldn't have been there in the first place. Back when this occurred, I believe it was in August.
Right.
As of now, if we redo it, we have 3102 on its face that he would currently qualify for.
I agree.
So under both of those, back in August, again, there was a permit that he should have applied for and he didn't, and it was denied.
I just
It was
don't
denied for a
know.
reason.
I don't
have that reason in
know.
front of me.
Yeah, I don't know. I do think it is prohibited by the code today, but the notice of violation is based under 18-8A. And what I've heard from the county on the point is that this has to do with changing a use.
You didn't change the use of property.
Any person commencing construction for which a permit is required without having first obtained said permit. But that's addressed separately under the window permit, it's addressed separately under the roof permit.
Well, under 18.8A, we're talking about erecting, constructing, enlarging, altering, or adding to the property without the permit. At the time of August occurred, everybody's agreeing, he required a permit to have erected or constructed a new device. And previously, this court has found that I believe it's the Webster's definition of either erect or construct, that moving the pod on the property does qualify as erecting or constructing a new building on the property, and he would need a permit for that. That's,
Okay, so
this
let's
court
look
has
at
previously
it.
found
Let's
that.
look at it. So
Rental containers.
what does the verb erect refer to in this sentence?
Let me get back to my Google search. Please moment. Please hold.
I think we also use development definition in the LDC for that.
I'm sorry?
I think we also looked at the development definition in the LDC. We looked at that as well. Prior.
To repair, move, improve,
And-
convert, change, use or demolish. Building or structure. So what it refers is to building or structure. Okay, so erect refers to building or structure. And I think what I found previously is that you're correct, that I found that a container is a structure.
If you build them.
Move, well, it says move here. It says erect.
They're not erecting anyway.
Well,
It's a-
let's look up, is there a definition of structure here, or can someone provide? I think this is a structure. They got you, Mr. Plauditz. How much time do you need to get these things off the property?
Let me tell something. When the permit of the Windows company was actually paid, in December, I paid for the renovation, for the extension. They told me it would be extended. So once they finish it, okay, now, I have to pay 3 months at least for shipping. So I need like 6 months, because I was willing to sell the property a long time ago. That's what it is. I'm asking like a 6 months extension. Because this only for the windows and put everything back, because this is a livable thing.
But windows, I mean, that takes, it doesn't take 6 months.
But there is 3 months, because I have to pay for the 3 months.
I see what you're saying. What's the county's recommendation? Is $100 a day?
$100 a day,
Okay.
yes.
Well, you've already had them there quite some time.
I was never told that it's illegal.
You had a notice of violation in September.
And I talked to them, I showed that there is no permit, I was there, I was trying to get it.
That was 5 months ago.
That's why I have to see that, with the matter with the judge.
Is there
What
anyone
he
from the
done.
public who wants to be heard on this? I don't want to deprive the public of an opportunity to speak.
I did everything what was possible on my end. I went to the county, tried to get the
Mr.
permit.
Planitz, I'll give you a month. I'll give you a month. But these have been there for 5 months already, some of them. One of them has been there for 6 months. The others have been there for about 5 months. Based on what you're saying, time's almost up anyways. So I'm gonna find a violation if it's not brought into compliance as ordered, a fine of $100 per day. Good luck.
No, that, okay. All right.
Next case on today's agenda, Greg G. and Pamela F. Helton and June Benjamin, case number 2023-01342. Code Officer Julie Wilkinson, page 16 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record.
Todd Benjamin.
Thank you, sir.
morning, or good afternoon.
Yes.
Excuse me. Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2301342. Abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 3360 South Anatole Way, Homosassa, Florida. Property owner is Greg G. and Pamela F. Helton and June Benjamin. I have good service via posting in the notice of hearing on the property. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on December 14th, 2023, corrective action inspection on January 11th, 2024. Photos of my final inspection conducted yesterday, February 20th, 2024. A copy, Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photo of the notice of hearing posted on the property, and a copy of the posting affidavit.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objections to them.
No objection.
Thank you. Thank you. Without objection, what's been proposed as Exhibits A and B are evidence.
On December 14th, 2023, I conducted an inspection and found that there is an abandoned vehicle on the property. On December 14th, 2023, an OV was issued for abandoned, unserviceable, and licensed vehicles. On January 11th, 2024, I conducted a corrective action inspection and observed the property remained in violation. As of my final inspection on February 20th, 2024, the property remains in violation. I had contact with Mr. Benjamin over here yesterday, who came from Texas and cleaned up the property. There was also junk and an overgrown lawn case, which he had abated yesterday. And he was in the process of getting the unlicensed vehicle abated, but the tow truck had not arrived, so I couldn't wait around. But I have been informed that the car has been removed, and I saw a photo on his phone with the timestamp of yesterday and this morning that it's been removed.
Do you require inspection before abating it?
Yes.
Okay. Do you have any objection to that?
No.
All right,
I just got a 16-hour drive. I'm just ready to go.
okay.
Is there grounds for dismissal at this point?
I mean, it doesn't sound like there's any evidence that there is a violation.
I don't have an issue.
So it's up to the county, but
You can dismiss it. I don't have an issue.
okay, case dismissed. Thank you for coming.
Have a good one. Thank you, sir.
Thank you.
Sleep before you head back. Yes.
No. If there's any further things, Greg and Pam are deceased. June is the rightful owner. She lives in Illinois. She's 82 years old. Can't get her. How do I go about
She needs to
avoiding-
change whatever the contact information is on the property appraiser, probably among other things, and so that she makes sure all the records get to her and stuff like that.
We posted a house for, or home for sale by owner on the property and no trespassing sign, so hopefully that'll keep people from taking things.
Good luck.
Thank you. Thank you.
Thank you. Next case on the day's agenda, Jacob and Brittany Jennings Fatherly, case number 2024-00010, Code Officer Alan Jonason, page 13 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Please state your names.
Amending Jennings for Fatherly. That is my rightful legal name.
Jacob Fatherly.
Okay, thank you.
Alan Jonason, Citrus County Code Compliance Officer. This is a repeat violation and initially observed on 6 June 2023. The address of the violation is 4661 East Dartmouth Lane, Hernando, Florida. The case number is 202400010, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owner, Fatherly Jacob and Jennings Brittany, has previously been found guilty of the same violation at the same location on 21 July 2023, which was case number 2023-00162, with $0 in imposed fines. That case was abated on 18 September 2023. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, findings of facts and order acknowledging compliance from the previous case, 2023-00162. Exhibit B, photos I took during my initial inspection on 25 January 2024, and photos I took during my subsequent inspections on 1, 5, 7, 12, 15 February 2024, and photos from my final inspection on 20 February 2024.
Alan, you lost me on the dates.
Okay, 1, 5, 7, 12, 15, and then 27.
Of January, of
February,
February.
all February.
Thank you.
Exhibit C, a copy of the notice of violation and hearing sent to Fatherly Jacob and Jennings Brittany, a copy of the posting affidavit, a photo of the notice of hearing posted on the property, and a copy of the pre-hearing order.
Sir and ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
Sorry, I'm having a little bit of issues. I've got AFib and it's affecting me right now.
Okay, well,
Did
take
I
a
sit
seat.
too fast?
Would sitting down help, or?
No, I stood too fast and my eyes are not focusing for a second. My top blood pressure just like dropped. That's fine with me.
Okay.
I'm close, I'm loud. The only notice that we had received was the one that was in our yard.
Okay.
Yeah, that's not very.
Thank you. Okay, thank you. first, I'm just gonna look at Exhibit C to refamiliarize myself with. Actually, I meant Exhibit A. Okay, this was not my case. I was wondering why I didn't remember it. Let me just briefly review it. Okay. The exhibits are admitted as evidence. Please proceed.
Yes, sir. I conducted my initial inspection on 25 January 2024 and observed that the property was in violation of junkyard conditions. During subsequent inspections on 1, 5, 7, 12, and 15 January 2024, I observed very little change to the property. I have had brief contact with the property owner, but as of my final inspection on 20 January 2024, the property remains in violation. February, I'm sorry.
I think I can tell from the photos what's going on. What's y'all's perspective?
So the couch that you see in there, we use that to sit out in our backyard, and we have a projector that we put up, and we watch movies, television, football games in our backyard. We use that couch. We are not going to put the couch in on the porch, move it out each time that we do it, because it's heavy. We have a cement mixer in our backyard.
I think that's the least of the issues, to be honest. Yeah.
But we are also trying to renovate the inside. We can't afford a dumpster, which would put us in yet another violation. So we take advantage of an area unused by us, our child, and our dog to store such things, and we can't, when we can afford it, because I make $13 an hour, he makes $15 an hour to the junkyard. This has been an ongoing issue. We've been fixing this house for a while. We were never in violation until we got a new neighbor who had never talked to us.
That's how it works.
That we have had our grass grow in our backyard for the last 9 years during the winter months. We are both previous landscapers. We are letting the grass grow to avoid erosion and other things that can happen in our backyard. We have children, we have animals. We're not gonna have it to where our fence is coming down because of erosion and everything, because we do have sloped areas in our yard.
Well, look, that's not at issue. What's at issue is the junk and debris. And so there's a prior case here.
The prior
that-
case was from outside of the fence.
I wasn't done. It found that there was junk and debris, and your testimony at that time was that you were renovating on the inside. You're consistent, you know?
Mm-hmm.
The problem is, that was 8 months ago, and it's still a violation. Nothing's changed about that.
Can I
mean,
say something, please?
well, you can when I'm done. And so, nothing has changed about that. I don't know that I can, I mean, that means that you've been on notice for at least 8 months, that the exact same thing that was a violation before is a violation here. I wonder if, yeah, go ahead.
So the previous violation was from outside of the privacy fence.
Mhm.
Everything that you see back there is in our privacy fence, because we wanted to make sure outside was absolutely,
I see.
no, we didn't take anything out.
Yeah.
And everything like that, so we have everything in
It
back
makes
behind,
sense.
so
Yeah.
it wouldn't be seen that, so we have a 6-foot privacy fence. The only way you can see over it is if you are reaching up over it, or you are actively trying to see over it. So we're trying to our best within our means to renovate. Yes, it's a very long process. We are finding so many things out of compliance within our house that we have to abide by. have to get permits because we have to redo the electrical that we.
Ma'am, I wouldn't admit that in a court. I mean, this isn't like a court,
No,
but
like-
I wouldn't. I mean, and so
It's
what,
gonna
what I want
take
to
a
caution
while.
you, I don't want you to admit to more violations here, which I
Well,
think you
It's
have.
not something we've started yet on the electrical or
I
anything.
hope not. But so, look, I don't, there's no, everything you've said, there's no exception in the code for what you've said. There's no
Yeah,
exception.
We're not contesting that part.
What I think you're really talking about to me is a ground for minimizing whatever fine does occur. And because it's a repeat violation, I have no discretion on that. There's going to be a fine.
Yeah.
Let me ask if there's anyone from the public who wants to be heard on this case. There is, okay. Well, then I'd like to hear from the public before issuing an order.
Ma'am?
Yeah.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Your name, please?
Jane Ruwine.
Can you spell the last name?
Ruehrwein.
Thank you.
Thank you.
Welcome.
Thank you.
So this is your opportunity to tell me what you'd like.
Okay. So, it is not truthful that you have never spoken to me.
Oh, and you have to direct your comments to
Okay,
me.
it is not truthful that they have never spoken to me. In fact, they've been in my home. I am not the first person to complain about the property. Per their admission, the prior owner did also. She passed away. I purchased the house. If there's any renovations that are going on, I certainly haven't seen them because the hoard in the backyard.
The what?
can-
Oh, hoard.
The hoarding
Okay.
in the backyard continues to grow and grow and grow. They do have an in-ground pool, which is concrete. When I first purchased the house about a year ago, it was filled with junk and debris. We've had several conversations where, I've offered them my help, getting this cleaned up. Part of the fence fell down. I said, hey, I'll purchase this fence piece for you to help you put it back up. No. So none of that, what they just spoke of, is true. The pool eventually was covered with a tarp. Now, I've had many pools in my life. From being up north, in the winter when you cover a pool, the center needs to be elevated so that the water does not become stagnant and run down and odor. So now the pool is empty. Big concrete hole. It is not covered. The tarp now is thrown over along the fence line, which will again attract mosquitoes. I've found multiple rats on my property. Their home is not secured by exterior doors. There's multiple areas of the home where it's just junk and debris thrown in everywhere. They have multiple enclosed, semi-enclosed areas that are just covered with tarps. So it's like if you pick junk up, you throw it in this pile, or maybe you're gonna, put a tarp over it. There is no remodeling going on. It's a problem that continues to grow and grow and grow.
All right, is that it?
One other thing, I am a cat lover. I completely understand. There have been 2 litters of cats born on their property and lived on their property, who have since come into mine. The first litter, I took the 3 kittens, got them all neutered and shots. They're now living with me. Now, mama, 3 more kittens come. So nothing is being taken care of. The grass, the cats, the rats, none of it. The pool, no excuses. Thank you.
All right, thank you, ma'am. Now, you do have an opportunity to respond.
Yes, we've never fed any stray cats in the neighborhood, so her accusing us of that is way out of line. She's never been in our home, never been on our property, never been welcomed on our property. We talked to her when she first was looking at the house at my mother-in-law's, said, hey, okay, cool, you're moving in. The lady behind us was a nuisance, used to yell at us because we were outside talking. Yes. Whole nother story. She was a great lady, but she's off a rocker. She was on medication for it. The other time we talked to her, she was like, hey, I've got gnats in my area. What would you guys recommend? That was the only time I stepped foot on her property on the porch. She has never, ever seen the inside. She says she wouldn't know how it is. How she says our house is not secured by doors. We have screen doors. We have had CPS there because of those allegations that she has just said, and found that we are not in any violation. We are not neglectful of our child. So for her having the accusations that we are the cause of the rats, the cats, and our house isn't secure is grossly out of line. We have dealt with cops, CPS, code enforcement, health department, and the mosquito department.
That's why the pool's empty right now. I'm in power washing and cleaning it up.
We are renovating. We work. This is my one day off. I get to enjoy sitting in this with you all on my one day off. I work 12-hour shifts, 8 a.m., 8 p.m. I leave the house at 7 a.m. I get home at 9 p.m. Please tell me when she would know if I'm renovating my house.
Look, here's the ultimate issue for me. It's that whether you're renovating or not,
Yeah, I understand.
where you store the stuff matters. And so I guess you probably can't undertake a renovation project if it's going to lead to this. Because unless you're willing to bear the cost. And
Yeah.
the cost is going to be tough because there's an automatic daily fine for a repeat violation. So what's the county's recommendation?
If I could just elaborate on what the witness testified to, we did receive contact from the Citrus County Sheriff's Department about the pool and the mosquito issue. I met them there. We tried to make contact. There was nobody at the property. The Sheriff's Department talked to the neighbor, which is her father, indicated to her that if the pool wasn't drained by that following Monday, that it's a misdemeanor and there could be actions taken. I went out Monday to do my inspection and the pool had been drained. I want to give them credit for that, but I just wanted to elaborate on part of the neighbor's statement about the pool. The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $150 per day along with the administrative cost to begin on the date of the posting on the property, which was 29 January 2024, and continue until 20 February 2024. That would be 23 days at $150 per day, totaling $3,450, and a fine of $150 per day from this day forward until the violation is abated. We would also ask that the Special Master find that it is the respondent's responsibility to notify the Code Compliance Division when the violation has been abated in order to allow for reinspection.
All right, so what I'm going to do is I am going to find that a violation has occurred, that it is a repeat violation. For the from January 29th till today, I'm going to do $100 per day, not $150, based on your testimony about the hardship. But from today going forward, I am going to agree with the county at $150 per day until it's fixed. Okay?
Thank you.
Good luck.
Thank you.
Next case, Chad E. Martin, case number 2023-01256, Code Officer Julie Wilkinson, page 19 of your agenda. Experts on the case, Joanna Coutu and Samuel Costa.
I'm sorry, what page?
19.
Sorry.
That's okay.
Julie Wilkinson, Citrus County Code Compliance Officer. Case number 2301256, residential accessory uses, Citrus County Land Development Section 3101I. The address is 22 Balsam Street, Homosassa, Florida. Property owner is Chad E. Martin. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on December 5th, 2023. Photos taken during a corrective action inspection on January 17th, 2024. And photos from my final inspection conducted on February 20th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Is there anyone from the public who wants to be heard on this case?
Yeah, right.
This is under construction, special master retreat, isn't it?
Yeah, it's my fault.
Yes. Ordered it and delivered it about noon, we'd be in reserve permit.
Yeah.
It's the same. There's been no final inspection. Yeah.
Thank you. Without objection, what's been proposed as exhibits A and B are evidence. Have you had any contact with the property owner?
Yes.
Okay. What have they said about this?
She said they did have a safety barrier, and that they took it down to finish doing the concrete work around the pool, and that they were gonna put it back up. However, what they put back up, according to the expert building director, is that it's not the appropriate type of material. It's not gonna pass it doesn't, I'll let Ms. Arcasa attest to that.
Okay, great.
Yeah, doesn't meet the pool safety act. That's a child barrier.
Is this the orange
Yeah, it's like a
barrier?
plastic mesh, I think.
What would meet the, like,
It's like, there's several criteria to it. One is about 48 inches tall. If it's a screen enclosure, gates, the latch for the screen door has to be at like 54 inches. Just all kind of common sense thing.
Okay.
The kid can't be able to climb it. So if it's like a wire lap fence, the holes have to be such that a small foot can fit in it.
okay. And this is for pools, that are younger than like 30 years old or something?
Oh, yeah, it's been around a long time.
Yeah, it's been a while. Okay. What's the county's recommendation?
Due to the public health and safety concerns, the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $500 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owner once they were advised of the violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
Do they have to apply for a permit to install the protective barrier?
That would be to verify code compliance, yes.
How long does that process normally take?
That should be a couple.
They do it before they install it, right? So do they need to show you
On
plans?
new construction, it's required, yes.
So they have to show you plans?
Yes. Yes.
I'm just concerned with the amount of time. I'll go along with the county on the health safety concern as to the fine. I just don't know what the appropriate amount of time would be to not punish. Does that make sense?
It does. It should only have to go to one department for review, unless it's in flood, I don't know.
But they'd have to hire a contractor, like a GC for this?
No,
or-
no,
Okay.
homeowner could pull that.
Okay, all right,
And I'm sure the homeowner's insurance doesn't know about it.
okay. It's interesting. All right, then I will find that the property is out of compliance, but grant 45 days to bring it into compliance. If it's not brought into compliance, $500 a day.
Thank you.
All right.
That's it.
Next case on today's agenda. Everything Motors Incorporated, case number 2023-01125, Code Officer Brandon Norman, page 12 of your agenda.
Good afternoon, Brendan Norman. Oh, I apologize.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help me God? I do. Your name, please.
Richard Renshaw II.
Thank you.
And good afternoon, thank you for your patience.
No problem.
Thanks.
Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2023-01125, conflict with Central Water Facility as a violation of Chapter 42, Article 2, Section 42-39B of the Citrus County Code of Ordinances. The address is 8795 South Florida Avenue in Floral City, Florida, 34436. Property owner listed as Everything Motors LLC. I have good service via posting at the property in the Lecanto Government Building, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be the notice of 365 compulsory utility connection case packet provided by the Floral City Water Association, documenting the attempts to notify the property owner by certified mail or posting at their property. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the posting affidavit, along with the photo of the posted notice of hearing at the property.
Okay, sir, are you a representative of Everything Motors?
I own it.
Okay. I'd like to ask you to take a look at these documents.
If it's everything he just said, then we're good.
Okay. I mean, are you gonna connect?
Problem is money. I ain't got the money to do it, and the money they want, and then the money that it's gonna cost me to go from where they connect to where I gotta connect, ain't happening. I just don't have it. Everywhere around my place is concrete, pavement. I gotta pay somebody to come in there and do it. I ain't got it, and honestly, I'm getting ready to put the place on the market because it ain't making no money. I've had enough, so it's going. So if the next guy's gotta do it, if I have to do it to be able to sell the place, then I'm gonna have to figure something out, but there's just, I ain't got the money. It just comes down to that.
So you're not contesting?
No, sir, not at all.
What's the county's recommendation?
Citrus County Code Compliance Division would like to request that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this
How much?
violation. 50. This amount was selected based on the actions of the property owners once they revised the violation and is appropriate given the severity of the violation. To the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master to find its respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
Ma'am, you waited all this time.
Sorry.
Is there anything else that you'd like to present or say?
Back in May, Mr. Richard contacted us, collected our paperwork, and then we never heard from him again. I'd be willing to try to work out a payment plan with him if that is an issue. He's just got to reach out to us.
Do you have any concerns about the quality of the water from the Floral City water?
Not at all. I mean, I drink it right from the kitchen sink. I wish I had it at my house. I have a bad well at home, so I see both sides. The people that do have better wells, you know.
Which we do, unfortunately.
Yeah, I mean, his property is cars and motors, so it would be beneficial if he was at that building to drink regulated water because you don't know what's seeping into the ground at his current well with all the cars and the oil, things that are there at the property.
All right, well, thank you. I appreciate it. Is there anyone from the public who wants to be heard on this case? Boy, someone showed up for this one. That would be. All right, sir, so what I'm gonna do is I'm gonna hold precedent with the earlier case and grant 90 days to bring the property into compliance, either by obtaining a waiver or by connecting. So if it's not brought into compliance as ordered, there'll be a fine of $50 per day
It's 90 days from today.
when the order is signed.
You'll get a copy in the mail.
I'll sign an order, yeah.
Okay.
All right,
Appreciate it.
thank you.
Thank you.
Thank you.
Next case, George A. Reese, Estate, case number 2023-01124, Code Officer Brandon Norman, page 23 of your agenda.
Ma'am? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name for the record?
Betty Brown. That's Betty with an E.
Thank you.
Are you an heir or personal representative for the estate of George A. Reese?
No, I'm public.
Oh, you're from the public, okay. All right, please proceed.
Ms. Brown and I have talked in great detail about this.
And you
so-
have something to say about a connection to Central Water Facilities case?
George A. Reese, my cousin, has been deceased many years.
Okay.
And the lady who took care of him until he died.
Well, no, I'll allow you, I need to
Okay.
hear their case first.
Okay.
I apologize. Thanks.
Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2023-01124, conflict with Central Water Facilities, a violation of Chapter 42, Article 2, Section 42-39B of the Citrus County Code of Ordinances. This is for address 10881 East Gobbler Drive in Floral City, Florida, 34436. Property owner listed as George A. Reese. I have good service via posting of the property in the Lake Canto Government Building, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be a notice of a 365-day compulsory utility connection case packet provided by the Floral City Water Association, documenting attempts to notify the property owner by certified mail or posting at the property. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the posting affidavit that I completed, along with the photo of the posted notice of hearing of the property.
All right, so, yeah, go ahead. Sorry. What percentage of properties, when they're given notice, go ahead and connect?
So back in 2022, when we started this, we had 37 cases, and I think we've ended up with about 6 or 8 in front of you guys, 6 or 7.
So the rest did
Have
connect?
connected, yes.
Interesting, okay.
And that was all of Floral City that we serviced. We only had 38 homes in violation.
Oh, okay, well, that's what I mean is how many just automatically connect, what percentage connect after they get the letter?
All of them, but the ones that you've seen.
Well, I know, is it like 50%, 90%, most of them?
I'd say about 80%.
80? Okay. All right, let me take a look at these documents. Without objection, what's been proposed as Exhibits A and B are evidence. Are there any other people who want to be heard on this case from the public? Okay. And I'm not going to keep you waiting too long. I just have to understand everything and read it. So it's the county's testimony that there's an on-site well on this property?
It's the county's testimony that they're not connected to the central water facilities. As to if they have a water source on the property, I'm not aware. I just know that they're not connected to the central water source, which is B with Floral City Water Association.
Well, under the code section, it says all buildings served by on-site potable water systems must connect to and utilize potable water from a publicly owned. So I think it's an element of the section that there has to be evidence of an on-site potable water system. But the letters do say that, and so I guess.
I just haven't been able to get access to the property to actually see for myself, so.
Okay, I mean, I think I understand the county's case. Is there anything else you want to add before I hear from Ms. Brown?
Yeah, I just want to say that Ms. Brown has been in contact with me. She's working right now diligently to obtain the property back into her name. She
Okay.
wants to bring it into compliance, but she's unable to do so because of the fact that she's not the property owner or a trustee of the property. So, but she has made it very adamant that she wants to bring the property into
Okay.
compliance. So,
All right. Ms. Brown, I'd love to hear from you.
As I stated, my cousin George Reese has been deceased many years. The lady who provided for him and took care of him until his death has also been deceased now. She was a friend of ours. I think 3 to 4 years. George's will left it to her. She never got paperwork done, so therefore it goes to her heirs.
Correct.
I have been in touch with her son, one and only son, and his son. They want nothing to do with Citrus County anymore. They live in Clearwater, and it's probably a very good thing for Citrus County that they don't come back here. That's another story. But I have paid back taxes for the last 3 years. I paid last year's and this year's. I'd say maybe, I got all that in front of me. I filed for a reverse possession of property only last year because I was trying to keep it from going to tax sale because I knew 2 people who were looking at the property and there was no way that I could fight them for the money for the property at that time. So I paid up the taxes to keep it from going to tax sale.
Okay.
I have been in touch with, like I said, with him and with probate lawyers, with everybody. I can't do anything without I won't do a probate on, it has to be 2 probates. One from George Reese and one from Sissy Yvonne Royals, who lived there. That's starting at $5,000. I can't do anything there without a contract from Kevin Royals, the son. He was all in agreement with me at first, and now he's gone ghost. He won't answer me, he won't talk to me, he won't do anything. I have put out quite a bit of money so far. I had electrical, I was gonna hook up to electric, the same thing, I can't do it without it being in my name. There's electrical work at the, up above the lines that has to be done first before they can even inspect it. The water company, yes, I spoke to them, I tried to get it in my name, not without being in my name. So it's at a standstill until either the reverse possession or until I can get through to Kevin to sign a contract
What
with
is
me.
a reverse possession?
Adverse possession.
Oh, adverse possession. Got it.
Oh,
got it.
I'm sorry.
Are you living in the house?
No, I live right across the street.
I see.
They were my cousins. When my grandma was still alive, we had functions over there,
Okay.
and my father.
I
and
actually
all
think
that.
you can do it in one probate, but I'm not giving you legal advice, and I'm not your lawyer.
Right, I understand
I've done
that.
it before, but at
But
any
even
rate,
if so, I'm sorry, if I did the probate on it to bring it up to whatever, then all Kevin has to do is come in and say that he
Yeah,
wants the
that's
property and
right.
I'm out all the money.
That's right. All right. I mean, so what are you asking? What do you want me to take away from this?
I don't know. I don't even know where to go.
Okay,
Nobody
all
does.
right.
There's no answer.
Yep. I mean, the issue here is that if it's not done, if it's not connected and paid
Right.
for, and they have a metering fee, then there's going to be a fine from me.
Right. I understand that, and that's what we spoke of.
Well, taking that into, is that all your input?
I guess.
All right.
Can I ask her 2 questions?
Yes.
Have you been inside the home?
Have I been in a?
Inside the home, have you been in there?
Yeah.
Okay. Was there running water?
Oh, there was at that time.
Thank you.
Lots of years ago.
That's all I needed, thank you.
Okay.
They're-
Yes.
They're addressing an infirmity.
There,
of the
yes, I'm sorry.
factual
There is a
Yeah.
will on the property.
Yeah, good, okay. I'm
There
glad to hear
is.
that. All right. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they revised the violation and is appropriate given the severity of the violation. We would also ask that the special master make it the respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
All right, I am going to grant 90 days to get the connection, and if it's not brought into compliance as ordered, I think staying consistent, I'll do $50 per day. Just good luck.
Thank you.
That will still just go against George Reese, who is deceased.
Yeah, but against the property as well.
Okay, so
You
that
know.
if it's gonna take me another 5 years to acquire
There'll
it
be a
by this
lien
paperwork.
growing on the property that
Okay.
if you want to acquire clean title will have to be paid off or negotiated, okay?
Okay,
All right,
yes,
good
I
luck.
understand. Thank you.
Next case, Robert E. Rudder, case number 2023-01126, Code Officer Brandon Norman, page 25 of your agenda.
Good afternoon, Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-01126, conflict with Central Water Facilities, a violation of Chapter 42, Article 2, Section 42-39B of the Citrus County Code of Ordinances. This is for address 10770 East Cod Court, Floral City, Florida 34436. Property owner is listed as Rudder Robert E. I have good service via posting of the property in the Lecanto Government Building, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be the notice of a 365-day compulsory utility connection case packet provided by Floral City Water Association documenting attempts to notify the property owner by certified mail or posting at the property. And Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the posting affidavit that I completed along with a photo of the posted notice of hearing at the property.
Okay. Is there anyone from the public who wants to be heard on this case? Okay. Is there a case that y'all are waiting for? Or are you just enjoying the... That's right. That's why I'm asking.
First of all, when you said that lawyer said he was going to have a short, so I did.
Well, see, I've learned the hard way over the years, and that's why I asked if there's any resolutions. But are y'all here to speak about a case?
Yes.
The next one.
Okay, the next one. Good. All right. I just wanted to make sure that we were calling y'all up. Well, we have to get her out of here, and then we'll get y'all. So it'll happen. Is this your last case, ma'am? Okay. All right. Please proceed.
On December 26, 2023, I received a complaint that the property had failed to connect to the central water system. After the 365-day notice period, the property was found to be in violation of the above ordinance that I mentioned. The property remained in violation at my notice of violation corrective action inspection on January 26, 2024, as well as my pre-hearing inspection conducted yesterday, February 20th, 2024. I have had no contact with the property owner.
Have you had contact with the property owner?
Yes.
Okay. Can you tell me about it?
We've spoken often. He was trying to comply.
I see that in your notes.
Yeah, so his was financial burden. I went to our board of directors, asked for a different payment plan option for him. They granted him one. We kind of went back and forth. On Friday, he told me he had our money. Our office was closed for construction on Friday and then subsequently closed President's Day, and I have yet to hear from him. I expected him to be here. He had told me he was going to come.
Okay.
So I'm assuming he'll connect, but then he hasn't reached out to us since he did on last Friday, so I'm not positive.
Okay, fair enough. Thank you. Is there anyone from the public who wants to be heard? I already asked. No. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owner once they revised the violation and is appropriate given the severity of the violation. We would also ask the special master make it the respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
I admit Exhibits A and B as evidence. I find that the property is in violation. Grant 90 days from the date of the order to comply, and if it's not brought into compliance as ordered, $50 per day.
Thank you.
Thank you.
Next case, Kathy Joe and Maxwell Moran. It's case number 2024-00046. Code Officer Julie Wilkinson, page 21 of your agenda.
Julie Wilkinson, Citrus County Code Compliance Officer. This is a repeat violation initially observed on January 10th, 2024. The address of this violation is 46 Jamaica Street, Homosassa, Florida. Case number is 2024-00046, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owners is Kathy Joe and Maxwell L. Morans. They have been previously found guilty of the same violation at the same location on June 22nd, 2023. That case number is 218-6857 with $1,390.43 in imposed fines, and that case was abated on August 14th, 2023. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, findings of fact, the order acknowledging compliance, and the order imposing fine from previous case number 2186857. Exhibit B, photos I took during my initial inspection on January 10th, 2024, and photos I took during my subsequent inspections on January 19th, 23rd, 24th, 30th, February 1st, 6th, 8th, 13th, 15th, and photos from my final inspection on February 20th, 2024. Exhibit C, a copy of the notice of violation and hearing sent to Kathy Joe and Maxwell L. Morantz, a copy of the posting affidavit, and a photo of the notice of violation and hearing posted on the property, and a copy of the general pre-hearing order.
Thank you. Without objection, exhibits A through C are admitted as evidence.
I conducted my initial inspection on January 10th, 2024, and observed tools, tarps, plastic totes, discarded furniture, a vacuum, bedding, loose trash, miscellaneous junk and debris on the property, which is a violation of the Citrus County Code of Ordinances. I posted the repeat notice of violation and notice of hearing on the property on January 19th, 2024. During the inspection conducted on January 19th, 2024, Mr. Morantz walked the property with me as I showed him the violations. There is a very strong odor of death and decay, and I observed a dead rat near the trash cans. I advised Mr. Morantz of the dead animal. During the next inspection on January 23rd, the dead rat remained. During the inspection on January 24th.
Did he know about the rat? I mean, did you let them know, or?
Yeah, absolutely, I let them know, yes. On January 24th, 2024, 4 other dead rats were observed, as well as several piles of used cat litter that had been discarded outside. There was some slight progress towards abatement with the removal of furniture that had been stored outside. On January 30th, 2024, and February 1st, 6th, 8th, 13th, and 15th, their property remained in violation with some progress towards abatement. Only a few items remained that needed to be stored properly. On February 20th, 24, the violation was finally abated and the property is in compliance.
Okay. I welcome any members of the public who wish to speak to come and be heard.
Now, when you said it's in compliance, did they take the mold off of those back walls?
Sir, if you don't mind, this is your opportunity to address me and.
Well, I just need to know.
Sir, for the record.
Okay, I have pictures.
No, sir, stop.
Oh, sworn in, okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I sure do. I got about 10 years of it.
I need your name, please.
My name is Frank, middle initial L, last name spelled Kellerer, and I am the third.
Okay. Thank you.
Okay, this isn't the first time.
Right.
Back 2018, I thought my trash smelled a little stinky. Well, guess what? About 3 days later, this was in February, probably got to be about 85, 90 degrees. I seen about 100 black blowflies next door. Now, we're in Sugar Mill Woods in those small villas. We're talking 2 feet away from each other. There was 6 dead rats that they left in that trash can probably for about at least 2 weeks, maybe 3.
This is back in 2018 you're talking about.
2018.
Okay.
This is an ongoing violation. Well, how would you like to smell all that shit? First of all, it's a health hazard. It's also a fire hazard. I'm sure those folks.
Well, just so you
don't-
know, this is on YouTube. We don't know who's watching. It's a public
I don't
meeting.
care who's watching it.
Well, you should.
No, I don't.
Well, then I'm not going to hear from you.
Well, look,
so,
look,
no,
sir.
no. Listen to what I'm going to tell you, okay? I really want to hear what you have to say, and you have a right to say it. You don't have a right to use words like SH word. This is a public hearing. I just have to ask you to speak with decorum.
Okay.
Thank you.
Okay, like I said, 2018. I have pictures in my phone. I don't know what pictures she had, but I can show you not one rat. This has been going on. When we left last year, the end of April, we were looking out in our yard. We usually try to feed the birds. Well, we didn't see one little rat. We didn't see two little rats. Well, we might have seen 10 little rats. And then, in the back part of the yard, they got about this much of their soffit missing. Now, guess what we hear? We hear big rats, probably about like this, running up and down the rain spout, going up in their soffit, all up in their house.
Do they have kids?
Oh,
Do you know?
They got about 3 or 4 dogs that live in there. They have 1, 2, 3 adults, and sometimes another female friend that might live there. But anyway, I have pictures of the soffit. Now, the new neighbors that moved in across the street, luckily we have them now, because like I said, are you familiar with Sugar Mill Woods?
A little.
This is supposed to be an upstanding community, I thought. That's why we moved in there. Now, I can afford a much higher cost of living if I want to in that development, but I'm only there for 4 months, maybe 5. I own property in Pennsylvania. We don't have to deal with that up there because I live out up home. No houses around me. So we're not used to this kind of living, and we shouldn't have to put up with it. Now, the HOA up there, their house is just getting off the rat problem. It's a blight problem. I want to sell my property, but when somebody comes in and want to buy my property and they look at the house that sits 2 feet beside me, guess what? I can't get the value that I should get for it. And that's not right. I blame the HOA. I'm about ready to call ABC News and get them to come up here and look at the situation and maybe have it on public television. Since this Sugar Mill Woods is supposed to be an upstanding community. Oh, sir, do you want to see any of these pictures I have on my phone of these rats?
I can't take it if it's on the phone.
Just curious.
If they're printed,
But I go out to
I'm
empty
sorry.
my trash.
Like,
Okay.
let me just answer your
I
question.
go out to empty my trash.
Sir, if you don't mind, can you hear me okay?
Yeah, I can
Oh,
hear you,
all right,
but
all
I'm
right.
just trying to point out,
Yeah,
I'm
yeah.
about
So
2
the
or
answer to
3
your
foot.
question about the photos is, if they were printed, I would be able to.
Well, we
but
did have, excuse me, did she show you some pictures of the rats?
just hold on a second. So, if they were printed, I could take them as evidence, but because they're on the phone, I can't.
Well, we did have some
Um,
printed ones now.
That's okay. I believe. I'm not in disbelief that there is a major rat problem.
Well, and also, this gentleman next door, he leaves holes in his house. Now, I got a hole this big. I was sitting out there taking about 10 pictures right in a row. He got a pipe coming out, but these rats are poking in and out of that hole. The house is really, I can't believe it. Sugar Mill Woods lets him get away with this type of property. I mean, I pay taxes to you folks, and I pay them at the full cost. I don't get no Homestead Act.
Well, presumably you pay the HOA too.
Yeah.
Assessments.
And I've been up there and talked to them, and that's like dancing in the wind.
All right. I appreciate it. Is there anything else you want me to know?
Well, no. What would you like to live beside somebody like that?
Do you have any other input?
No, sir.
Thank you.
You're welcome.
Is there anyone else from the public who'd like to be heard?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Your name, please?
Glenn Fiola, F-E-O-L-A.
Thank you.
Thank you, sir.
The gentleman who lives next door he was talking about was me. I bought the house a year and a half ago. What bothers me is the house is in decline and all that. The first time I seen a rat, I told my wife, the house looks run down and stuff like this. I'll go to the neighbors, give me 100, give 100, you know, and we'll get rid of the problem. Just don't ever let them come back. When I talked to Frank, this problem's been going on for like 9, 10 years. It's been cleaned up a couple times and all that. I'm just wondering, in difference from New Jersey, if there was that, the state would go out and not fine, they would relocate or do something to get the problem fixed. But I told Max when I seen the first rat, I said, look, you got rats, you gotta do something about it, and it was, that offended me. Nothing's been done about it. We've been complaining, going to the HOA, whatever that is. I'm just wondering if there's a way that somebody can help these people out or resolve the problem. Rats don't go away, they multiply. My dog killed one on my driveway, and I'm across the street. I don't want this to accelerate to something bad, you know what I'm saying? But I don't know who's gonna do something or has to do something, but something should be done.
All right, thank you.
Is this an issue for the health department?
Health department's been, everybody, excuse me.
We've notified,
we
we've notified.
went
Hold on,
around
sir,
in
sir,
circles.
sir, if you don't mind, I'd like to hear from Mr. Trone.
Yes, ma'am. We've notified environmental health also on this case. That was one of the first calls we made when we got the case.
So, and I think one of the reasons for that is that my powers are really fairly limited most of the time. They may be expanded under a case like this, but we can talk about it, okay?
No, it's property value, all that, but somebody's living in this house with rats. I mean, not one rat, I mean rats.
Well, that's why I asked about the kids. I saw a baby chair, I thought, in the pictures, but I'm not sure.
Well, excuse me, sir, they did have two children living there, young ones, okay, probably about 1 year old. His wife got pregnant, and they were expecting another child, but in the meantime, the two didn't evidently get along. She was from Arkansas. When Max was in jail and his mother went to jail back then, she took off, called her folks to come and get her, and she went back.
Okay, then that answers, thank you. That's a good thing for the kids, probably. All right, so what is the county's recommendation on this?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative costs to begin on the date of the posting of the property, which is January 19th, and continue until February 20th, 24. That would be 32 days, $150 per day, totaling $4,800.
And, it's in compliance. So,
Yes.
it's, okay, all right. Do you know who brought it into compliance? Have you had direct contact in the last few days with the owner?
Yes, I've had contact with both the mother and the son, I kindly asked him to finish picking up the junk that was outside yesterday, and I watched him do it. So he's the one who's been cleaning up the property.
Do you think that this is a problem? I mean, it's recurred for so long. Do you think it's going to happen again?
Yes, I
Okay,
do believe it's
okay.
going to happen again.
Are you only asking for a fine? Do you think that it's been fixed, it's been abated, so
Yeah.
there's nothing to go in there and clean up at this point?
I think that, yes, I'm only asking for a fine. I just don't know what other resources there could be because I don't know the jurisdiction or who has jurisdiction about the conditions on the inside of the house, which I am assuming, and from smells, when Ms. Morantz has opened the door,
Is
are
worse.
unlivable,
Yeah.
yes.
Yeah, but that's not really what this code case is.
Exactly, exactly.
What do you think, Mr. Trone?
And I've had conversations with the complainants before, and that's the real issue. They state that the source is coming from the inside, and we don't have any access or jurisdiction inside the property. With a lot of cases for slum and unsafe conditions, we have that access through the sheriff's office.
That's what I'm wondering. I
And
mean,
this case,
you can't establish, I'm not trying to goad the county into anything, by the way, so this is just an academic discussion, but you can't determine whether it's, I guess you have no way of determining whether it's blight or slum without.
Right.
And have you asked to go inside?
I
mean,
I
you're
have
wearing a mask
not-
here, so God knows what you would need to get into there. I mean, I don't know.
Yeah, no, I have not asked to go inside. No.
I'm not proposing that, and I'm not saying that you've made a mistake.
Yeah.
I'm not saying anything. I'm just curious
Yeah.
for my own
There-
purposes.
I have been told, though, that I've asked the age of the lady, and she's over 65, so I don't know if that would help anything. And the sister of Mr. Maxwell and the daughter of the older lady living there, I've been told has some kind of disability. So I don't know if there's any protections there either.
Yeah.
I just don't know the resources.
I'm just concerned by the public input we've heard and the fact that this is a repeat case. It sounds like it'll come back in front of me about 3 or 4 months from now.
Mhm.
And then we
But at that time, things might be different about what I can do.
we even reached out to the HOA as well.
Sir, I'm sorry.
We don't wish to speak to anyone.
Yeah. No, sir, I meant it. I'm.
Fine, you would impose.
All right.
I
what's-
wish what they would do.
Sir,
that money-
I appreciate
they
that
would
you
put it on
came
their
and had
property,
input.
fix their
I already let
property
you
up.
speak twice, and I'm not even supposed to do that. So, all right. Well, here's what I'm going to do. I'm going to find that the property is in violation. I appreciate I have some real concerns, and my only ability, given these facts, is the fine. So I am going to increase the fine, recognizing, they may not have much means, but this is a really serious, we need them to wake up immediately about this. So the amount of the fine for the repeat violation, I'm gonna have it be, $300 a day instead of $150, and that'll raise the total amount from $4,800 to $9,600. The max, of course, is I think $1,000, if I recall. But anyways, I've never done that. So that's it. I'll issue
Thank
the
you.
order.
Thank
And
you.
I appreciate the public coming and letting us know what's really going on there. Well, hopefully it doesn't happen again.
Yeah.
Thank- Talk to code enforcement.
Next case, Michael Charles Putsch and Michaeline Rochelle Raber. Case number 2023-01302, Code Officer Alan Jonason, expert on the case Joanna Coutu, page 11 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2023-01302, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102. Address of the violation is 7026 East Munoz Court, Hernando, Florida. Property owner is Charles Putsch Michael and Raber Michaeline Rochelle. I have good service via posting the NOH on the property and posting it to the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 13 December 2023. 3, photos from my compliance inspection on 17 January 2024, and photos from my final inspection conducted on 20 February 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, and a copy of the posting affidavit.
Thank you. So for the record, I don't see any other members of the public here, so I'm going to dispense with asking the public if they have any input. Exhibits A and B are evidence.
On 13 December 2023, I conducted my initial inspection and observed the property to be in violation. On 13 December 2023, a notice of violation was issued for special requirements for accessory structures, which is a violation of the ordinance mentioned earlier. On 17 January 2024, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 20 February 2024, the property remains in violation. Land Development Director Joanna Coutu is my expert witness.
Thank you for your patience.
No worries. This is Coastal Lakes Residential, mobile homes allowed. It's only about 1/10 of an acre. It should be vacant. They don't own any abutting properties.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
30 days, $100 per day.
Thank you.
Next case, Arrowhead Investments of Southwest Florida LLC, case number 2023-01251, Code Officer Alan Jonason, page 8 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2023-01251, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 3611 East Sutter Lane, Inverness, Florida. Property owner is Arrowhead Investments of Southwest Florida, LLC. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 6 December 2023, photos taken from a compliance inspection on 8 January 2024, and photos from my final inspection conducted on 20 February 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, a copy of the pre-hearing order, and a copy of the SunBiz.
Thank you. Did you take these photos on the dates indicated?
Yes, sir.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully request that the special master assess a fine of $150 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Exhibits A and B are admitted as evidence. Was it $100?
$150.
Okay, $150 per day, 30 days.
Thank you, sir.
Next case, 3 cases on the agenda. Howard Weldner, cases 2023-01252, 01320, and 01328, pages 32, 33, and 34 of your agenda. Code Officer Brandon Norman, Joanna Coutu, expert on case number 2023-01328.
Thank you.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-01252, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Case 2023-01320, abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. And lastly, case 2023-01328, fences, hedges, and walls, a violation of Section 3150 of the Citrus County Land Development Code. This address is 8191 East Cooper Lane in Floral City, Florida, 34436. Property owner listed as Weldner Howard. I have good service via posting at the property in the Lecanto Government Building, and I would like to authenticate the following documents and request they be admitted into evidence for all 3 cases. Exhibit A will be photos taken during the initial inspection on December 7th, 2023, my corrective action inspection done on January 11th, 2024, and my final inspection done February 19th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, as well as a photo of the posted notice of hearing of the property.
Okay, thank you. So it's exhibits A and B in each case?
A and B in each case.
All right,
correct.
they're all admitted. Let me first ask you about the junkyard conditions. Did you take these photos on the dates indicated?
I did.
Okay, let me ask you about the unlicensed vehicle case. How many vehicles are subject to this?
Currently, as of February 19th, there's one RV, one pickup truck, and one other pickup truck, so 3 in total.
And are they all untagged or are they out of date?
Inoperable.
Oh,
They have
okay.
flat tires
Gotcha.
or either missing components that would allow them to.
And you've taken the photos indicated in Exhibit A for this case
I
on the
have.
dates indicated?
I have.
All right, would you all please offer testimony regarding the fencing case?
I do have an expert.
Yep.
Residential lot, just under an acre. They have residential on 3 sides. Across one of their streets is industrial, but the 3 sides will say that, you can't have the barbed wire there.
Oh, it's barbed wire?
There's barbed wire as well as a fence with the proper materials.
Okay, okay. And I do see that in the photos.
It's kind of hard to make out. The property is severely overgrown. It's taken over by squatters currently, and it's just progressively getting worse.
I can make it out. What's the county's recommendation in all 3 cases?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $300 per day along with administrative costs for each case to begin after the date that you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they revised the violation. This amount is appropriate given the severity of the violations and the respondent's actions relative to the violations. We'd also ask the special master find its respondent's responsibility to contact the Code Compliance Division in order to allow for reinspection once the violations have come into compliance. The reason why we're asking for $300 is it's progressively getting worse. There's about 7 to 8 individuals that are on the property, and every time I go out, you can tell from the junkyard conditions photos, it's going downhill. I've met with one of the occupants there. He's not going to come into compliance.
Did not go well.
It did not go well. No.
Okay. In case number 2023-01320, I'll allow 60 days and $300 fine if not brought into compliance. On the other 2, it'll be 30 days and $300.
Thank you.
Okay.
Next case, Lacanto Land LLC and Jack Fulford, Code Officer Brandon Norman, case number 2023-00997. Expert on the case, Joanna Coutu, page 18 of your agenda.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-00997, billboard maintenance, a violation of Chapter 9, Section 9290 Echo of the Citrus County Land Development Code. Address is 1110 South Lacanto Highway, Lacanto, Florida, 34461. Property owner listed as Lacanto Land LLC and Jack Fulford. I have good service via posting of the property in the Lacanto Government Building, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on October 6, 2023, my corrective action inspection on November 27, 2023, a subsequent inspection on January 8, 2024, and the final inspection done February 19, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and the posting affidavit that I completed with a photo of the posted notice of hearing of the property. I do have one correction though. For my inspection, I apologize, I misspoke. It was February 20th.
Okay.
So. I had a lot, so I had to break it up over 2 days. So.
I've never had a billboard case brought in front of me. Thank you.
On October 6, 2023, I conducted an inspection of the property for a complaint of poor billboard maintenance. I found the property to be in violation due to debris surrounding the billboard and it overall being dilapidated. The billboard remained in violation at my corrective action inspection, but I was contacted by the property owner shortly after and informed they had a crew hired to clean up the property and bring it back to its condition that it's supposed to be in as per the ordinance. They requested additional time, to which I obliged. I re-inspected the property on January 8th, 2023, and observed no change. As of my inspection done on February 20th, 2024, the property remains in violation. At this time, I would like to refer to my expert.
And for billboards, they're limited on where they can go. This is one place. I don't have any indication that they could not replace this or repair it. They just haven't. So.
Do you know if there's a permit on it?
There was in 1997. That's when it was placed. Yeah. So it's time to redo it. I don't have an indication they couldn't.
Yep.
But they have not.
Okay, interesting. What's the county's recommendation?
Citrus County Land Development, Citrus County Code Compliance Division respectfully request that the special master assess a fine of $150 per day along with administrative costs beginning after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners. Once they're advised of the violation, and this amount is appropriate given the severity of the violation.
Can you revoke the permit based on what's happened?
Since 97, I don't think so.
And do they have to get another permit to fix or put new stuff on it? or-
Yes, they will need another permit to even put new screws and stuff in.
Wow. Okay, then I will grant 60 days because I'm not sure
I just
about
don't know where the
permit.
communication stopped at, which was
Yeah,
really
no,
weird to me.
I'm just not sure about permit compliance.
Yeah.
So I think that's gonna be a reasonable time period, and if it's not brought in compliance, $150 a day.
Great, thank you.
Thank you.
Next case, Deanne and Michael Hauser, case number 2024-00035, Code Officer Cody McGuire. Joanna Coutu is the expert, page 15 of your agenda. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Wow, welcome to the show.
I know.
Welcome to the show.
All right, y'all ready?
Yes.
Citrus County, or Cody McGuire, Citrus County Code Compliance Officer. Case number 2024-00035, special requirements for all accessory structures, a violation of the Citrus County Land Development Code 3102A. Address is 11267 North Nighthawk Terrace, Inglis. Property owner is Deanne and Michael Hauser. Good service via posting the property and posting it at the Canto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on January 8th, photos taken during a corrective action inspection on January 23rd, and photos of my final inspection conducted on February 20th, 2024. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, and a copy of the posting affidavit, and a photo of the notice of hearing posted on the property, and a pre-hearing order.
Is this the only case you have today?
While we're waiting, Ms. Coutu, do you want to testify, or do you have anything you want to add?
This one, sure.
Yeah.
Sure. 2 minutes.
I'm just
Right
trying
off.
to-
No, I appreciate it, yes. Okay, so these particular owners actually applied for an electric permit in 2022 for a well pump. It was denied. You can't have electric on a vacant lot. So I know they've been aware since at least 2022 that they could not have development at this site. It is about a 1 acre site residential.
Wow, okay. And Mr. McGuire, have you had contact with the property owner?
Yes, sir, I have.
Tell me about it.
It's been pretty extensive, actually. At first, I thought I was getting a runaround with it, and I started doing follow-up phone calls with the mobile home companies that she was providing me with. And lastly, the one that I called said that they did apply for a home. There just was no signs of any permitting done on our end.
I mean, have they indicated that they want to get a permit, or that they want to go?
Yes,
through the
sir.
process? Oh.
Yep, they really do, from what she says, and intend on, or want to live out there.
Okay. This address says Inglis. Is Inglis in Citrus County?
It's just
Are you
before the
serious?
bridge, the last street on the left.
But the address for
Yeah, but, well, okay, so the city is not, the actual city, the unincorporated part. Wow, okay. And you took the photos on the dates indicated?
Yes, sir.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $100 per day along with administrative costs to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when a violation has been abated in order to allow for a reinspection.
I'm so hungry that I don't hear when you give the fine amounts anymore. That's why I keep asking.
Okay.
And so that started around 11 o'clock,
Okay.
just so you know. I mean, it's not, that'll make it worse. No, that's not, that doesn't feed a human being.
You need to start packing lunch.
I
I'm just
should.
saying.
What is the fine amount that you said?
$100 per day.
Okay. Do you know what they want to do with the property? Like what exactly they're doing?
Right now,
No, what they want to do.
putting a
Like,
mobile home on it.
mobile home? All right. I'll grant 90 days if it's not brought into compliance as ordered. I'm so sorry. What did you say?
$100 per day.
Okay, $100 per day. Thank you.
Thank you.
Next case, Catherine A. Santiago and Fialo Angel Johan Menace. Case number 2023-01171. Code Officer Brandon Norman, expert Joanna Coutu, page 26 of your agenda.
Good afternoon, Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-01171, trucks parked in selected land use districts, a violation of Chapter 3, Section 3320A of the Citrus County Land Development Code. The address is 3130 South Signet Terrace in Inverness, Florida, 34450. The property owner listed as Fialo Angel Johan Menace and Avila Catherine A. Santiago. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on November 9th, 2023, an inspection on January 2nd, 2024, a corrective action inspection on January 25th, 2024, and photos of my final inspection done February 20th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the pre-hearing order, as well as a copy of the signed certified mail return receipt.
And it's changing colors now.
We're almost done. We're almost done.
Thank you.
On November 9th, 2023, an initial inspection was conducted of the property for a truck parked at a residence. The property was found to be in violation of the above ordinance that I mentioned. The property remained in violation on an inspection on January 2nd, 2024, and a corrective action inspection done on January 25th, 2024, as well as my pre-hearing inspection done February 20th, 2024. I have had contact with the property owner, and they are aware of the violation and how to come into compliance. I've had this case before. Previous case, they came into compliance. Now they're just attempting to park the truck behind the home. I've gained permission from the neighbor to use his property to look at it. It's actually getting to the point where they're starting to destroy his property because they essentially drive into his property to get to behind their house. And it's causing some damage on his side. You can see it from the last photo that I took. You can actually see the ruts starting to form. And they're starting in the neighbor's property leading into theirs.
It does say that if it was allowed, it wouldn't be allowed in a front yard.
We don't even go there, though. We're not even gonna get to that.
No, I know. I'm just saying, I mean, I don't know if that's where they get the idea. Probably not. Okay.
But we've had a conversation before with Miss Santiago specifically, and I've explained to her in great detail that the truck cannot be parked there at the residence.
All right. Any other testimony?
Sorry, it's half acre and CLR. There's no way to get there. I can't get them there
Yep.
with a conditional use or anything else.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. The amount is appropriate given the severity of the violation as well as the respondent's actions relative to this violation. We would also ask that you find that the respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
7 days, $150 a day.
Thank you so much.
Next two cases on the agenda, Zeta Maria Bork, case numbers 2023-00896, 2023-01300. Code Officer Cody McGuire, page 9 and 10 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer. Case number 202301300, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. Address is 10710 North Autumn Oak Point, Crystal River. Property owner is Bork Zadia Maria. Goods service via signed certified mail return receipt and posting at the Canto Government Building. I would like to authenticate the following documents and request they be admitted.
You're doing both the cases at once?
I could.
I
Yeah, let's do them together.
Do them
yeah, if you-
together?
if you
Okay.
wouldn't mind.
And then case number 20230896, unlicensed / inoperable vehicle, a violation of Chapter 20, Article 6, Section 20-31 of the Citrus County Code of Ordinances. Everything was on the same dates. My initial inspection was on, one I have initial inspection on September 25th and the other one is December 6th. Do you want me to read them separate?
No.
No, okay. So one initial inspection was on the 25th, and then the following were December 6th, January 8th, and February 20th of 2024. Exhibit B would be a copy of the notice of violation, copy of the notice of hearing, and a copy of the signed certified mail return receipt.
And are there photos from both the September 25th and December 6th occasions?
One has September 25th, and the other one's December 6th.
Yes, I just wanted to make, it doesn't matter to me. I'll be able to tell from the photos.
Oh, okay. What was the
Oh, you
question
mean
again?
for the orders, Lori?
Yeah.
Okay, I'm sorry.
Which one was the 25th?
The 25th was the unlicensed vehicle.
Thank you.
Okay.
Okay.
Thank you. Exhibits A and B are evidence in each case. Please proceed.
Okay. Do you want just
No, actually, let me go to the overgrown.
overgrown?
On the overgrown, did you take the photos on the dates indicated on Exhibit A?
Yes.
Okay, I see the case there. Certainly, Exhibit A corroborates there's a violation. And on Exhibit A, on the unlicensed vehicle case, what are the vehicles subject to this case?
The boat
Just the boat?
in the driveway, yes, sir.
Okay.
There was multiple vehicles prior, but on the 20th, their boat remained.
I got you. So as of today, it's only the boat?
Correct.
All right. How were you able to tell? Were you able to see that from your vantage point?
From the roadway, yes, sir. Yep. And one time, the property owner did allow me on the property, and there was no registration then on it.
Okay. What's the county's recommendation in each case?
It's the same for both. Okay. The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $100 per day per violation, along with administrative costs to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask that the special master additionally find that it's a respondent's responsibility to contact the Code Compliance Division when a violation has been abated in order to allow for reinspection.
On the overgrown case, it'll be 14 days and $100 per day if it's not brought into compliance. On the vehicle, I'm going to give 60 days and $100 per day if it's not brought into compliance.
Thank you.
Yep.
Next case on the day's agenda is Cynthia L. Wilson, case number 2023-01324. Code Officer Brandon Norman, page 36 of your agenda.
Brandon Norman, Citrus County Co-Compliance Officer. This is for case 2023-01324, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is for 105 East Inverness Boulevard in Inverness, Florida, 34452. Property owner listed as Wilson Cynthia L. I have good service via posting at the property in the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on December 26, 2023. A corrective action inspection done January 25th, 2024, and my final inspection done on February 19th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and the posting affidavit that I completed along with a photo of the posted notice of hearing at the property.
All right. Thank you. Exhibits A and B are evidence. And did you take the photos on the dates indicated?
I did. There's been some change, some improvement, but there still remains a violation. But I've had no contact with the owner either, so.
Do you think the property's occupied?
No, it's vacant.
It is vacant. Oh, I see.
Yeah.
Yep.
It's just
All right.
it's not storage on a vacant, it's just junk and debris that's on
I
there.
see it. What's your recommendation?
Citrus County Code of Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This fine was selected based on the actions of the property owners once they're advised of the violation and is appropriate given the severity of the violation and the property owner's actions relative to this violation. We'd also ask that you find that the respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
About how big is the property?
Less than a quarter of an acre.
Okay. I'll grant 30 days, $100 a day.
Thank you.
Next case, Linda G. Rice, trustee, case number 2023-01295. Code Officer Cody McGuire, page 24 of your agenda.
Cody McGuire, Citrus County Co-Compliance Officer, case number 2023-1295, 01295. Accumulation of junk and debris. A violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 6371 West 7 Rivers Drive, Chris River, Florida. Property owner is Linda G. Rice, trustee, Linda G. Rice Living Trust. Good service via sign, certified mail return receipt, and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A's. Photos taken during the initial inspection during December 7th, corrective action inspection on December 21st, and photos of my final inspection conducted on February 20th, 2024. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
Thank you. Did you take the photos in Exhibit A on the dates indicated on the photos?
Yes, sir, and I also have had contact with the property owner's daughter.
Okay, well, and how did that go?
Unfortunately, it was sad. They came from out of state to help the mother out, and when they were here, the mother had passed.
Oh, they didn't know.
What's that?
They didn't know the mother had passed?
No, during the time that they came down to help her
Mother
clean it up,
passed.
the mother passed away. Yes, sir.
So presumably Linda Rice passed away?
Yes, sir.
I see. All right, well, given those circumstances, what do you recommend?
I would really honestly just want administrative costs. I mean, they've done a huge, they've abated the lawn case, and the junk that was there, they said was in no correlation. It was an illegal dump that was in the driveway. If you look at the photos, they do match interior stuff, but what was in the driveway it didn't seem to match any other debris that was on the property.
I mean, I agree it doesn't look awful at this point, but you do have a situation where the owner's not even there. It's not clear whether the other folks are gonna be, or it's just not clear to me whether they're gonna clean it up or not. So I think you still need it's not in compliance today, correct? I mean, the photos I saw from yesterday.
Correct.
Okay.
Well, in that case, I would do $50.
Okay. Are they still here?
No, sir, they had to go back up.
Yeah. All right, so that's tough. But it's not that much.
It's really not, no.
All right, then, that's It's not that much. I'm just gonna grant 30 days and
30.
$50 a day.
Okay.
Yep.
Thank you.
Last two cases. Pamela Henley Weiss, case numbers 2023-00667 and 2023-00705. Code Officer Julie Wilkinson, page 37 and 38.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 2300667, accumulation of junk and debris. A violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, and case number 2300705. Unlicensed inoperable vehicle, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 6051 South Hancock Road in Homosassa. Property owner is Pamela Henley Wise. I have good service via signed certified mail via posting the notice of hearing on the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during initial inspection on August 17th, 2023. A corrective action photos from a corrective action inspection on January 4th, 2024. And photos of my final inspection conducted on February 20th, 2024. Exhibit B, a copy of the notices violation, a copy of the notices of hearing, and a copy of the general pre-hearing order, a copy of the notices of hearing posted on the property, and copies of the posting affidavits.
And this is for both cases?
Yes,
correct?
sir.
Okay. Exhibits A and B are admitted in each case. Now, as pertains to the photos in Exhibit A in each case, you took the photos on the dates indicated?
Yes, sir.
All right, then let me just look through briefly. Junkyard conditions seems well established under the photos. Have you had contact with the property owner?
Not the property owner, but occupants of the property.
But what?
I've had contact with people at the property,
Oh, right.
but not
Oh,
the
occupants.
Yeah, the occupants.
I
Yeah.
thought you said objects for a second. I was like, All right, and have they indicated responsibility or willingness to clean up, or?
They have made a huge improvement in the property, but there's just still some items left that they are just not picking up.
And as of the date of your last inspection, how many vehicles are still subject to violation?
3.
3. Have you talked to them about it?
Yeah, so the woman staying at the property is saying that the vehicles belong to the property owner. However, she's told me that she can't get in contact with the property owner. The property owner lives up in New York. It's very weird. I don't know what's going on with the vehicle. So she's saying she can't do anything with vehicles. But then she says she got permission to have the vehicles towed away, but then they're not towed away. I'm getting all kinds of stories, so I don't know what's true and what's not.
Fair enough. What's the county's recommendation on these cases?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day per violation, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally to find that it's the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
All right, I'll do 30 days in each case and a $100 fine per day in each case if it's not brought into compliance.
Thank you.
That concludes the cases on the agenda, correct? Is there anything else that the county would like to take up while we're here? All right.